Please be seated. Now we are going to hear first batch of evidence in what I call Block 1, which is to help us get an understanding of the way the Perth entities, the Burswood entities, were governed and operated, and the interaction with the Crown Group. So, Mr. Poynton, please. Okay. If you come over, and if you wouldn't mind just remaining standing and give us your full name for the purpose of the record.
John Hartley Poynton.
And do you wish to swear or affirm?
Affirm. I, John Hartley Poynton, sincerely declare and affirm that the evidence I give to this Commission shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Poynton. Please sit down. Mr. Ward.
Thank you, Commissioner. Mr. Poynton, have you prepared a witness statement in response to the summons to you by the Commission?
I have.
Do you have a copy of that there?
I do.
It's the witness statement dated the 20th of July 2021.
Yes.
Is there a correction that you wish to make to paragraph 25 of that statement? Can you say what that is?
In paragraph 25, it refers to the acquisition of Burswood Limited being made by CPH, Consolidated Press Holdings. It was actually made by PBL, Publishing and Broadcasting Limited, which is a predecessor company to CPH.
And subject to that one correction, is the balance of your statement true and correct to the best of your knowledge and belief?
It is.
You attend to that statement, sir.
Thank you. The witness statement of Mr. Poynton, which dated the 20th of July, and which bears the identifier WIT.0009.0001.0001 will be admitted as an exhibit. Thank you, Mr. Ward. Ms. Cale.
Thank you, Commissioner. Mr. Poynton, just before we get going, you've got another document there under your witness statement.
Yes, sorry.
Two documents.
Two documents, I do.
Just tell me what they are.
One is a series of references to board minutes from the 14th of December 2016, just for if I need to refer to particular parts of those minutes. The other is just a briefing note on the structure of the company and its committees, just for my reference. I'm happy not to have them, but they were just for my my memory jog, if you like.
All right, well, we might just ask your counsel to make copies available
Sure,
to us in due course.
And the only other statement is obviously that.
Just the witness statement?
The witness statement, yeah. And I have a pad, but just to take notes if necessary.
All right, thank you. Now, we're going to show you documents on the screen,
yes,
including your witness statement. Your witness statement copy, in hard copy you've got there, does it have any annotations?
No, none at all, which I'm happy to show you.
So if it has no annotations, then would you prefer to look at the hard copy? Or
It's probably better on the screen, right. Yeah.
So let's go to page 005 then. And we're just at that paragraph that you were at where you made the amendment.
Yes.
And in the first sentence, you talk about being asked to assist CPH in its negotiations for the possible acquisition of the share capital in Burwood. Just to clarify, you did in fact provide that assistance, did you?
Yes, yes. It was narrowed to just discussions with the two substantial shareholders referred to, being Mr. Bendat and Mr. Wiley. And I guess on behalf of the PBL entity, conversations about whether they would be prepared to sell to PBL.
All right, thank you. Now, you go on to say in your witness statement that after the takeover was completed, you were offered a position as a non-executive director of Burswood Limited by James Packer, and then over at paragraph 26, you explain that you had no specific experience as a director or executive of any business that operated casinos.
Correct, correct.
Had you derived any understanding of the nature of the Perth casino business and its operations through that assistance you provided CPH?
Not really, no.
Right.
At that point, it was just made up of, I guess, being an observer of the company when it was listed.
At the time you were appointed a director of Burswood Limited in 2004, did you understand or have any appreciation that casino operations were particularly vulnerable to the risk of being used to facilitate money laundering?
Not specifically, although even when Burswood itself was a listed company, there was often speculation about the people gambling at it.
When you say not specifically, did you have a general understanding that casinos were vulnerable to the risk of being
Yes,
facilitated
yes, I did.
to use money laundering? And you didn't ever change that understanding in the course of being a director of Burswood Limited? You always remained of the view that casinos were vulnerable to the risk of money laundering?
Yes, correct.
When you were appointed in 2004, did you understand that casino operations were particularly vulnerable to the risk of being infiltrated by criminals and organised crime syndicates?
Not particularly, no.
Generally?
Generally, yes.
And again, you remained of that understanding during your tenure as a director,
Yes.
and in fact, you would have come to appreciate better the risks of criminal infiltration of casinos.
Over time, certainly into the 2016, 17, 18 period.
Did you understand at the time of your appointment in 2004 that junket tours posed particular risks to the operations of casinos hosting those tours?
I had no particular knowledge of junket operations, so not specifically, no.
What about generally? Did you understand generally what junkets were then?
Generally, yes, I suppose. I mean, I didn't really turn my mind to it specifically.
And did you understand generally that they posed risks in terms of using casinos and their operations to facilitate money laundering, or they were fronts for organised crime syndicates?
It would be the same answer. Generally, yes. Specifically, no.
And as your time wore on as a director of Burswood Limited, you became aware of that risk more acutely?
Much later.
By which you mean 2017, 2018?
Well, by which time I mean, I suppose, around the time of the accusations. I mean, there were various media stories.
So you're pinning that at 2018, 2019?
Well,
now,
yes. So, but there was, I think, a story on Four Corners back in about 2014, and then, as you say, the 60 Minutes and Fairfax articles in 18.
Did you understand at the time of your appointment in 2004 that some people who gamble, whether at casinos or elsewhere, can develop an addiction to gambling?
Yes.
And for some people, gambling can cause them harm. For example, they can end up gambling themselves into bankruptcy.
Yes.
Did you understand at the time of your appointment that people who regularly play electronic gaming machines are at particular risk of developing a gambling addiction?
I didn't have any specific knowledge or concern about that.
What about a general understanding or concern?
General, yes.
Now, obviously, you knew during your tenure as a director of Burswood Limited that Burswood Nominees Limited was the licensee of the Perth Casino, didn't you?
I did.
And that Burswood Resort Management was the manager of the casino.
Indeed.
And you understood that it was the employer of most of the casino's staff.
Yes.
And you understood that each of Burswood Nominees and Burswood Resort Management had their own board of directors?
Yes.
And
Executive directors.
Right. You were never a director of the licensee or Burswood Resort Management.
No, I wasn't.
And as you say, those boards were each comprised of persons who held executive positions at Crown or Burswood Limited, is that right?
Indeed, that's correct. So the board on which I was a director had no staff, one asset and one shareholder.
You understood that both Burswood Nominees and Burswood Resort Management were wholly owned subsidiaries of Burswood Limited?
Could you ask the question again, sorry?
You understood, didn't you, that both Burswood Nominees Limited and Burswood Resort Management were wholly owned subsidiaries of Burswood Limited?
Yes.
In the context of that corporate structure that we've just discussed, what precisely was the business of Burswood Limited during the time that you were a director of the company?
So the business of Burswood Limited was that it was itself wholly owned by, ultimately, Crown Resorts. There were two intermediary companies above it, and it had one asset, which was the unit or units in the Burswood Property Trust, and it had no executives and no staff.
So you've
So
just,
its business was to, as I was concerned, was to essentially look after the interests of its shareholder,
being Crown Resorts.
ultimately Crown Resorts.
Now, I'm going to ask you some questions about the casino licence and the casino licensee, understanding that Burswood Nominees had other business interests associated with the Burswood Resort. I'm going to ask these questions relevantly only to the Perth casino business, and I'd ask you to confine your answers accordingly, unless you need to expand
Right.
to make sense of your answer and to make it complete.
Yeah.
So these questions are not about Burswood Limited, they're about the casino licensee. And they'll seem somewhat formulaic, but if you'll just bear with me and answer
Sure.
accordingly. At the time of your appointment in 2004, did you seek to inform yourself of the nature and content of the obligations that Burswood Nominees Limited had as licensee of Perth Casino?
In a general sense, well, it's a long time ago. I would have studied that in some detail. I just don't recall specifically.
By going to the state agreement, for example?
Well, I think at the time of the takeover, there was some analysis of the state agreement.
Did you read the state agreement?
Not in full.
Did you read it at all at the time that you started as a director of Burswood Limited?
I can't recall specifically what I read. I would have made, if I recall, some analysis or some, but in a general sense.
At the time of your appointment in 2004, did you consider that in its capacity as licensee of the Perth Casino, Burswood Nominees Limited had responsibilities to the state of Western Australia?
Burswood Nominees, yes.
And did you consider that Burswood Nominees Limited, as licensee of the Perth Casino, had a responsibility to the state of Western Australia to mitigate the risk of the Perth Casino operations being used to facilitate money laundering?
Yes.
In 2004, did you consider that Burswood Nominees Limited, as licensee of the Perth Casino, had a responsibility to the state of Western Australia to mitigate the risk of the Perth Casino operations being infiltrated by criminals or organised crime syndicates?
In a general sense, yes.
What do you mean by that?
Well, I had no specific involvement in Burswood Nominees, so I would have been aware of a broad obligation to conduct its business in a legal manner and not to any prejudice to the state.
In 2004, did you consider that Burswood Nominees Limited, as licensee of the Perth Casino, had a responsibility to the state of Western Australia to reasonably mitigate the risk of Perth Casino patrons developing gambling addictions?
Yes.
In 2004, did you consider that Burswood Nominees Limited, as licensee of the Perth Casino, had responsibility to the state of Western Australia to reasonably mitigate the risk of harm to casino patrons caused by playing games on electronic gaming machines?
I would have answered that in the sense of a general obligation to mitigate any risks of harm, not specifically around electronic games, just gambling in general.
At the time of your appointment in 2004, did you understand that in Western Australia, gambling via the use of poker machines was prohibited?
Sorry, could you ask the question again?
At the time of your appointment in 2004, did you understand that in Western Australia, gambling via the use of poker machines was prohibited?
Yes, I did.
At the time of your appointment in 2004, did you consider that it was important for the Perth casino operations to be conducted in a way that maintained the confidence of the West Australian public in the integrity of those operations?
Yes.
At the time of your appointment in 2004, did you consider that it was important for the West Australian public to have confidence that the licensee of the Perth casino was of good character and integrity?
Yes.
Can I ask you some questions now about Burswood Limited specifically, the company that you were a director of? Now, you've already mentioned that Burswood Nominees Limited, as you understood it, the board was comprised of an executive management team. So you did not understand that there was going to be any governance of the Perth casino operations by the Burswood Nominees Limited Board. Is that right?
By the Burswood Limited Board or the
Burswood Nominees Limited
There
Board.
was not going to be any governance.
Of the Perth casino operations by that board because it was an executive board.
No, I would have imagined that it would be charged with the governance of that business.
That a managerial team would have governance over the managerial team?
Well, ultimately, because Limited and nominees were wholly owned subsidiaries of the headco, ultimate responsibility rests with the people that own all the equity.
So let me just understand that you're saying that at Crown Resorts Limited, that was where the governance responsibility lay.
Well, I guess what I would say is that if the directors of Limited served at the pleasure of the head company and could be removed at any time, then ultimately the power exists in that place, the board of headco.
Did Crown Resorts Limited, on your understanding, have any oversight and governance responsibilities for the management of the Perth casino operations?
Ultimately, yes.
And what do you mean by ultimately?
Well, as I said a minute ago, they owned all the shares in all the subsidiary companies. They appointed the directors to the boards of the subsidiary companies, and therefore could direct and govern the relationship through those boards with the licensee.
Who had immediate oversight or governance responsibilities in respect of the Perth casino operations?
The immediate and most direct connection was between nominees and the licence with the government.
The executive
Yes.
board?
Yes. Bearing in mind the executives also had national roles.
And your position is that Burswood Limited, their board had no governance responsibilities, no oversight responsibilities in relation to the Perth casino operations?
As is seen frequently through the minutes, we would be minuted as saying we recommend adoption of. That's not directing the subsidiary company that we own shares in.
So just to come back to my question, did Burswood Limited, in your view, have any governance or oversight responsibilities in relation to the Perth casino operations?
Only in regards to monitoring the actions of Nominees Limited.
And when you say monitoring, what do you mean by that?
So the board packs that came and the reports that came to Limited were a combination of things that had been developed by nominees in conjunction with the executives and indeed the risk committees and other committees of headco resorts. So the extent to which we had governance oversight, it was to ratify things that had been agreed elsewhere or recommend adoption of, for instance. It's being the director of a wholly owned subsidiary is different, obviously, from being the director of a company that actually employs staff and operates a business. And it's probably worth at this juncture to say, at the time of my appointment, it was envisaged that the directors, the non-management, let's not call them non-executives, the non-management directors of Limited were appointed to be, and I've used the term elsewhere, ambassadors. So they were there to provide political and economic overview about the situation in Western Australia. It was never envisaged.
Please be seated. Now we are going to hear first batch of evidence in what I call Block 1, which is help us get an understanding of the way the Perth entities, the Burswood entities, were governed and operated, and the interaction with the Crown Group. So, Mr. Poynton, please. Okay. If you come over, and if you wouldn't mind just remaining standing and give us your full name for the purpose of the record.
John Hartley Poynton.
And do you wish to swear or affirm?
Affirm. I, John Hartley Poynton, sincerely declare and affirm that the evidence I give to this commission shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Poynton. Please sit down. Mr. Ward.
Thank you, Commissioner. Mr. Poynton, have you prepared a witness statement in response to the summons to you by the Commission?
I have.
Do you have a copy of that there?
I do.
It's the witness statement dated the 20th of July 2021.
Yes.
Is there a correction that you wish to make to paragraph 25 of that statement? Can you say what that is?
In paragraph 25, it refers to the acquisition of Burswood Limited being made by CPH, Consolidated Press Holdings. It was actually made by PBL, Publishing and Broadcasting Limited, which is a predecessor company to CPH.
And subject to that one correction, is the balance of your statement true and correct to the best of your knowledge and belief?
It is.
You attend to that statement, sir.
Thank you. The witness statement of Mr. Poynton, which dated the 20th of July, and which bears the identifier WIT.0009.0001.0001 will be admitted as an exhibit. Thank you, Mr. Ward. Ms. Cale.
Thank you, Commissioner. Mr. Poynton, just before we get going, you've got another document there under your witness statement.
Yes, sorry.
Two documents.
Two documents, I do.
Just tell me what they are.
One is a series of references to board minutes from the 14th of December 2016, just for if I need to refer to particular parts of those minutes. The other is just a briefing note on the structure of the company and its committees, just for my reference. I'm happy not to have them, but they were just for my memory jog, if you like.
All right, well, we might just ask your counsel to make copies available
Sure,
to us in due course.
And the only other statement is obviously that.
Just the witness statement?
The witness statement, yeah. And I have a pad, but just to take notes if necessary.
All right, thank you. Now, we're going to show you documents on the screen,
Yes.
including your witness statement. Your witness statement copy, in hard copy you've got there, does it have any annotations on it?
No, none at all, which I'm happy to show you.
So if it has no annotations, then would you prefer to look at the hard copy? Or
It's probably better on the screen, yeah.
So let's go to page 005 then. And we're just at that paragraph that you were at where you made the amendment.
Yes,
And in the first sentence, you talk about being asked to assist CPH in its negotiations for the possible acquisition of the share capital in Burwood. Just to clarify, you did in fact provide that assistance, did you?
yes. It was narrowed to just discussions with the two substantial shareholders referred to, being Mr. Bendat and Mr. Wiley. And I guess on behalf of the PBL entity, conversations about whether they would be prepared to sell to PBL.
All right, thank you. Now, you go on to say in your witness statement that after the takeover was completed, you were offered a position as a non-executive director of Burswood Limited by James Packer, and then over at paragraph 26, you explain that you had no specific experience as a director or executive of any business that operated casinos.
Correct.
Had you derived any understanding of the nature of the Perth casino business and its operations through that assistance you provided CPH?
Not really, no.
Right.
At that point, it was just made up of, I guess, being an observer of the company when it was listed.
At the time you were appointed a director of Burswood Limited in 2004, did you understand or have any appreciation that casino operations were particularly vulnerable to the risk of being used to facilitate money laundering?
Not specifically, although even when Burswood itself was a listed company, there was often speculation about the people gambling at it.
When you say not specifically, did you have a general understanding that casinos were vulnerable to the risk of being
Yes,
facilitated
I did.
to use money laundering? And you didn't ever change that understanding in the course of being a director of Burswood Limited? You always remained of the view that casinos were vulnerable to the risk of money laundering?
Yes, correct.
When you were appointed in 2004, did you understand that casino operations were particularly vulnerable to the risk of being infiltrated by criminals and organised crime syndicates?
Not particularly, no.
Generally?
Generally, yes.
And again, you remained of that understanding during your tenure as a director,
Yes.
and in fact, you would have come to appreciate better the risks of criminal infiltration of casinos.
Over time, certainly into the 2016, 17, 18 period.
Did you understand at the time of your appointment in 2004 that junket tours posed particular risks to the operations of casinos hosting those tours?
I had no particular knowledge of junket operations, so not specifically, no.
What about generally? Did you understand generally what junkets were then?
Generally, yes, I suppose. I mean, I didn't really turn my mind to it specifically.
And did you understand generally that they posed risks in terms of using casinos and their operations to facilitate money laundering, or they were fronts for organised crime syndicates?
It would be the same answer. Generally, yes. Specifically, no.
And as your time wore on as a director of Burswood Limited, you became aware of that risk more acutely?
Much, much later.
By which you mean 2017, 2018?
Well, by which time I mean, I suppose, around the time of the accusations. I mean, there were various media stories.
So you're pinning that at 2018, 2019?
Well, yes. So, but there was, I think, a story on Four Corners back in about 2014, and then, as you say, the 60 Minutes and Fairfax articles in 18.
Did you understand at the time of your appointment in 2004 that some people who gamble, whether at casinos or elsewhere, can develop an addiction to gambling?
Yes.
And for some people, gambling can cause them harm. For example, they can end up gambling themselves into bankruptcy.
Yes.
Did you understand at the time of your appointment that people who regularly play electronic gaming machines are at particular risk of developing a gambling addiction?
I didn't have any specific knowledge or concern about that.
What about a general understanding or concern?
General, yes.
Now, obviously, you knew during your tenure as a director of Burswood Limited that Burswood Nominees Limited was the licensee of the Perth Casino, didn't you?
I did.
And that Burswood Resort Management was the manager of the casino.
Indeed.
And you understood that it was the employer of most of the casino's staff.
Yes.
And you understood that each of Burswood Nominees and Burswood Resort Management had their own board of directors?
Yes.
And
Executive directors.
Right. You were never a director of the licensee or Burswood Resort Management.
No, I wasn't.
And as you say, those boards were each comprised of persons who held executive positions at Crown or Burswood Limited, is that right?
Indeed, that's correct. So the board on which I was a director had no staff, one asset and one shareholder.
You understood that both Burswood Nominees and Burswood Resort Management were wholly owned subsidiaries of Burswood Limited?
Could you ask the question again, sorry?
You understood, didn't you, that both Burswood Nominees Limited and Burswood Resort Management were wholly owned subsidiaries of Burswood Limited?
Yes.
In the context of that corporate structure that we've just discussed, what precisely was the business of Burswood Limited during the time that you were a director of the company?
So the business of Burswood Limited was that it was itself wholly owned by, ultimately, Crown Resorts. There were two intermediary companies above it, and it had one asset, which was the unit or units in the Burswood Property Trust, and it had no executives and no staff.
So you've
So its business was to, as I was concerned, was to essentially look after the interests of its shareholder,
being Crown Resorts.
ultimately Crown Resorts.
Now, I'm going to ask you some questions about the casino licence and the casino licensee, understanding that Burswood Nominees had other business interests associated with the Burswood Resort. I'm going to ask these questions relevantly only to the Perth casino business, and I'd ask you to confine your answers accordingly, unless you need to expand to make sense of your answer and to make it complete.
Yeah.
So these questions are not about Burswood Limited, they're about the casino licensee. And they'll seem somewhat formulaic, but if you'll just bear with me and answer accordingly. At the time of your appointment in 2004, did you seek to inform yourself of the nature and content of the obligations that Burswood Nominees Limited had as licensee of Perth Casino?
In a general sense, well, it's a long time ago. I would have studied that in some detail. I just don't recall specifically.
By going to the state agreement, for example?
Well, I think at the time of the takeover, there was some analysis of the state agreement.
Did you read the state agreement?
Not in full.
Did you read it at all at the time that you started as a director of Burswood Limited?
I can't recall specifically what I read. I would have made, if I recall, some analysis or some, but in a general sense.
At the time of your appointment in 2004, did you consider that in its capacity as licensee of the Perth Casino, Burswood Nominees Limited had responsibilities to the state of Western Australia?
Burswood Nominees, yes.
And did you consider that Burswood Nominees Limited, as licensee of the Perth Casino, had a responsibility to the state of Western Australia to mitigate the risk of the Perth Casino operations being used to facilitate money laundering?
Yes.
In 2004, did you consider that Burswood Nominees Limited, as licensee of the Perth Casino, had a responsibility to the state of Western Australia to mitigate the risk of the Perth Casino operations being infiltrated by criminals or organised crime syndicates?
In a general sense, yes.
What do you mean by that?
Well, I had no specific involvement in Burswood Nominees, so I would have been aware of a broad obligation to conduct its business in a legal manner and not to any prejudice to the state.
In 2004, did you consider that Burswood Nominees Limited, as licensee of the Perth Casino, had a responsibility to the state of Western Australia to reasonably mitigate the risk of Perth Casino patrons developing gambling addictions?
Yes.
In 2004, did you consider that Burswood Nominees Limited, as licensee of the Perth Casino, had responsibility to the state of Western Australia to reasonably mitigate the risk of harm to casino patrons caused by playing games on electronic gaming machines?
I would have answered that in the sense of a general obligation to mitigate any risks of harm, not specifically around electronic games, just gambling in general.
At the time of your appointment in 2004, did you understand that in Western Australia, gambling via the use of poker machines was prohibited?
Sorry, could you ask the question again?
At the time of your appointment in 2004, did you understand that in Western Australia, gambling via the use of poker machines was prohibited?
Yes, I did.
At the time of your appointment in 2004, did you consider that it was important for the Perth casino operations to be conducted in a way that maintained the confidence of the West Australian public in the integrity of those operations?
Yes.
At the time of your appointment in 2004, did you consider that it was important for the West Australian public to have confidence that the licensee of the Perth casino was of good character and integrity?
Yes.
Can I ask you some questions now about Burswood Limited specifically, the company that you were a director of? Now, you've already mentioned that Burswood Nominees Limited, as you understood it, the board was comprised of an executive management team. So you did not understand that there was going to be any governance of the Perth casino operations by the Burswood Nominees Limited Board. Is that right?
By the Burswood Limited Board or the
Burswood Nominees Limited
There was
Board
not going to be any governance.
of the Perth casino operations by that board because it was an executive board.
No, I would have imagined that it would be charged with the governance of that business.
That a managerial team would have governance over the managerial team?
Well, ultimately, because Limited and Nominees were wholly owned subsidiaries of the headco, ultimate responsibility rests with the people that own all the equity.
So let me just understand that you're saying that at Crown Resorts Limited, that was where the governance responsibility lay?
Well, I guess what I would say is that if the directors of Limited served at the pleasure of the head company and could be removed at any time, then ultimately the power exists in that place, the board of headco.
Did Crown Resorts Limited, on your understanding, have any oversight and governance responsibilities for the management of the Perth casino operations?
Ultimately, yes.
And what do you mean by ultimately?
Well, as I said a minute ago, they owned all the shares in all the subsidiary companies. They appointed the directors to the boards of the subsidiary companies, and therefore could direct and govern the relationship through those boards with the licensee.
Who had immediate oversight or governance responsibilities in respect of the Perth casino operations?
The immediate and most direct connection was between Nominees and the licence with the government.
The executive
Yes.
board?
Yes. Bearing in mind the executives also had national roles.
And your position is that Burswood Limited, their board had no governance responsibilities, no oversight responsibilities in relation to the Perth casino operations?
As is seen frequently through the minutes, we would be minuted as saying we recommend adoption of. That's not directing the subsidiary company that we own shares in.
So just to come back to my question, did Burswood Limited, in your view, have any governance or oversight responsibilities in relation to the Perth casino operations?
Only in regards to monitoring the actions of Nominees Limited.
And when you say monitoring, what do you mean by that?
So the board packs that came and the reports that came to Limited were a combination of things that had been developed by Nominees in conjunction with the executives and indeed the risk committees and other committees of headco resorts. So the extent to which we had governance oversight, it was to ratify things that had been agreed elsewhere or recommend adoption of, for instance. It's being the director of a wholly owned subsidiary is different, obviously, from being the director of a company that actually employs staff and operates a business. And it's probably worth at this juncture to say, at the time of my appointment, it was envisaged that the directors, the non-management, let's not call them non-executives, the non-management directors of Limited were appointed to be, and I've used the term elsewhere, ambassadors. So they were there to provide political and economic overview about the situation in Western Australia. It was never envisaged, as in my recollection, that this company and its directors would be directly responsible for the management of the casino. And indeed, for the next 15 years, that was how it worked.
So we'll come back to that in a moment. I'll come back to ask you about that in a little more detail. But to go back to your first proposition that subsidiary holding companies generally have the responsibilities you describe, that very much depends upon the governance structure of the individual group of companies, doesn't it?
It does, indeed.
So it can change depending
Well,
how
it
they
can
set
change,
themselves
yes.
up.
And dare I say it, there's a number of precedents for that structure.
Now, if we go to page 0008 of your witness statement at paragraph 38, you're talking here, Mr. Poynton, in the context of when the Crown Resorts Limited, or CRL board. You're calling it HEDCO, aren't you, in your
Well,
answers?
for the purposes, we can call it Crown Resorts.
Now, which you joined in May 2018.
I was appointed, I was offered a role on the board and then had to undertake probity in New South Wales and Victoria, which took some months, and I was actually appointed officially to the board in November 2018.
Right.
Sorry, can you just repeat those dates, please?
I was offered a role not long after Mr. Packer resigned from the board of Crown Resorts Limited. I entered into a consultancy arrangement with his company in
I'm
May.
just sorry, I just missed the dates. Is it
The
August
date.
to November? Did you say?
November, yes.
Yeah, but
November
so-
18 was the date of my official appointment to the board.
And the invitation was around August, did you say?
Sorry?
The invitation for you
Oh,
to
no,
join?
that would have been probably April, May.
April, May, so it's the probity process is 6 months or so?
It was in New South Wales, Commissioner, yes. In Victoria, a shorter period, and I already had probity in Western Australia.
So, Mr. Poynton, I'm taking you to paragraph 38 of your witness statement. And what you're talking about there is, by reference to the earlier paragraph, the sorts of committees, board committees that CRL had. You see that? And then in the second sentence of paragraph 38, you say, as a director of Burswood Limited, I was generally aware of the charters and responsibilities of each of the above committees, and I understood that if any issues relating to the Perth casino was considered by those committees that required the attention of the board of Burswood, they would be appropriately escalated. See that?
Yes.
What sort of issues are you referring to there that would be required to be escalated on your understanding?
Well, and there weren't any, but matters to do with AML, CTF, matters to do with problem gambling, matters to do with concerns that the regulator may have had with the with nominees.
So to this extent, you understood Burswood Limited did have some oversight or governance responsibility in respect to the Perth casino operations?
No, I'm saying that we would have been made aware of it from a reputational point of view, and as I said earlier, we had no power to direct. As a wholly owned subsidiary and two non-management members of that board, we were not able to direct, but we were receiving information about matters to do with the casino, to do with the matters you've referred to, and other matters to do with the financing of the group. But it was always clear to me that we had no ability to say to nominees, you should do this or you should do that. It would have been much more around escalating to HEDCO or resorts any concerns that we might have had and have them direct what needed to happen.
Now this division of responsibilities that you've described as between the CRL board and the Burswood Limited board, indeed Burswood Nominees Limited board, was that ever documented?
Not that I'm aware of, no.
So there was no document that explained that your role was limited to an ambassadorial one, as you've described?
The operation of the company over time from 04 onwards made it clear to me what was expected of our board.
It should have been documented though, shouldn't it, as a matter of good governance to ensure that there were no misunderstandings about who was required to do what within the corporate group?
Well, over time it was very clear how it was operating, and I don't think documenting it may have been helpful, but I think we, the non-exec or the non-management directors of Limited, knew what we were appointed to do, which was to provide information, as I said, and to monitor, I guess, from a reputational point of view, what was happening.
So is it your evidence that documenting the responsibilities of Burswood Limited board directors was something that would simply be helpful, but certainly wasn't required as a matter of good governance of that board?
If I'd felt that it wasn't clear to me what my responsibilities were, yes, documentation might have been required, but at all times it was clear to me.
What about the other directors?
Well, I can't speak for them.
What about the CRL board? Were you sure that it was clear to them what you were doing or not doing?
Well, all I could go on was whether internal audit, external audit, the regulator or anybody was escalating matters either through limited or to CRL, and I at no stage was made aware of any of those concerns.
Burswood Limited did not have a corporate charter during your tenure as a director, did it?
No.
Were you aware before you joined the CRL board in 2018 whether CRL had a board charter?
Yes, I think before it did, yes.
And you were certainly aware once you joined CRL
Sure.
of the board charter, weren't you?
Yes.
If we go to CRL.506.007.78.78_R, here we have a agenda for a CRL board meeting in February 2019 at 8110. We have the then company secretary with a memorandum to do with the review of charters. If we cursor down, please, the first one referred to in the memo is a board charter for CRL, which management has reviewed with some suggested amendments for the board's consideration. And if we then cursor down past the memorandum, we see the board charter, and onto the next page, please. And the next. You'll see there in section 1 at page 8113, it sets out clearly what the board is responsible to do.
Yes.
And it goes on to describe duties, responsibilities and powers of the board. Do you recall that much?
Yes, I do.
Was it clear to you from reading the board charter for CRL what the responsibility of CRL was in relation to Perth Casino's business?
Yes, as the owner of the assets ultimately, and the appointee of the directors to the subsidiary boards, it was clear to me that it was ultimately responsible for the operation of the Perth Casino.
You use that word ultimately again, Mr. Poynton.
Well, I'd take out the word ultimately. It was responsible.
Directly. And not Burswood Limited.
Burswood Limited was, as I said, a company that was in the chain of structures, had no staff, couldn't direct staff to do things, had one asset and one shareholder.
Did you consider, knowing that CRL had a board charter, that Burswood Limited should also have a board charter?
Given the fact that it was a wholly owned subsidiary of CRL, no.
We go to page 8114, please, and look at section 3.2 of this board charter. You see there is a section that deals with matters reserved for the board and goes on to list them. What matters were reserved to the Burswood Limited board?
The matters that Burswood Limited had information provided to it about were the operations of the casino in Perth. It had information regarding risk management, problem gambling mitigation. They came to the board of Burswood Limited as a pack for review. In some cases, as I said, when there was the need to adopt a particular thing that related to the operation of the casino, the wording in the minute said that the limited board recommended adoption by nominees.
So what was reserved to Burswood Limited on your evidence
Well,
was...
the matters, the substantive
Mr.
matters
Poynton,
that...
Mr. Poynton, just
Sorry.
pause because I'm finishing my question.
I'm sorry.
We just need for the transcript to have the question complete.
Sorry, I apologise.
So that then the answer is
Indeed,
complete.
sorry.
Because if you try and look at it when you read it later, it doesn't make much sense.
I understand, I apologise.
That's all right. So, on your evidence, then, do I understand this correctly? The matter, not matters, the matter that was reserved for the Burswood Limited Board was to, in certain circumstances, recommend to CRL Board that it make certain decisions.
No, it seemed to me that the recommendations went the other way. They went down to nominees. So, for instance, in an example of the adoption of AML CTF joint program, Limited looked at that program and recommended its adoption by nominees.
Well, that's a governance
It's a recommendation. It has no legal force.
But you were exercising oversight over Burswood nominees' operations in that capacity, weren't you?
We had no power to direct. So it's a semantic point. We were never in a position to direct either any employees, because we didn't employ anybody, and we certainly weren't in a position to direct what may happen with the subsidiary, because ultimately that direction was the purview of CRL.
So let me just explore that with you, Mr. Poynton. It's not semantic at all, is it? If Burswood nominees provided to you a report, speaking hypothetically and using an extreme to illustrate the case, they said, well, we've decided that we're actually not going to have any AML risk management at the casino. You would presumably, as a board, go back and say, well, we recommend against that. I think you should have a risk management system for AML. And if it then transpired that they acted against that recommendation, you'd just send it up the line to CRL, wouldn't you? So just answer that question.
I'm not sure I understand the question.
I'll repeat it.
Sorry.
Hypothetically speaking, Burswood nominees comes to the Burswood Limited Board and it says, we've decided to abandon any AML risk management. We're not interested to manage and mitigate risk of money laundering occurring at Perth Casino. Your board says, we recommend against that. That's a terrible breach of the risk management systems and the particular vulnerabilities of the Perth Casino. Burswood nominees decides to act against your recommendation. You're obviously going to report that up the line to CRL, aren't you?
If it happened.
Right.
But that's the problem with hypothetical. It never happened.
But the fact of the matter is that the structure was there for you as Burswood Limited Board to exercise oversight of the Perth Casino operations.
Oversight, but no direction and no power to direct.
Right.
So certainly one could go to, it never happened, members of CRL and express concern, but as is evidenced by all the reports that came, there were no red flags.
But that simply demonstrates, doesn't it, that your oversight, the oversight that you provided, you were comfortable with what Perth Casino operations were doing.
On the basis of the reports that we received from many sources, but particularly internal and external auditors, there were no red flags. There was never any issue raised, as far as I was concerned, that required from the regulator. I mean, if you think about the analogy, it would be like APRA talking to the director, a non-exec director of, say, Commonwealth Bank, or more specifically, Bank West. My experience is that that's not the way it works, and it certainly was never any flags in that regard.
So you accept that there was a degree of oversight without a power to direct.
Correct.
In relation to the Perth Casino operations.
Correct.
And I think you also described it in your own words as a monitoring function in relation to the Perth Casino operations.
Correct.
And these were the responsibilities that the Burswood Limited Board had.
If you use the term responsibility in the context of oversight.
Yes.
But not being able to direct.
Would you agree it was a failure of governance by the Board of Burswood Limited while you were there not to ensure that those responsibilities, you've just agreed that it had, were documented?
No.
Would you agree it was a failure of governance by the Board of Burswood Limited during your tenure not to ensure there was a Burswood Limited board chart?
No.
Now, coming back to paragraph 18 at page 0004 of your witness statement. You've got that there on the screen, Mr. Poynton?
Yes,
So here you are talking about the management team
indeed.
for the Perth Casino. You make an initial comment about management teams generally in your experience. And you say in the second sentence, you refer to having a high degree of trust and confidence in the management team's judgment, skills, competence and integrity in managing the Perth casino business. And you repeat that in a way at paragraph 24, don't you, at 0005?
Yes, indeed.
Did you consider the management team, or any of them, were ultimately accountable to the board of Burswood Limited for their management of the Perth casino operations?
Not directly.
Were they indirectly accountable to the board of Burswood
They were
Limited?
indirectly accountable to the group, or they were directly, in some cases, accountable to the group. As I said, and it's documented, Burswood Limited employed no executives. So again, there is no direct linkage between the board of Burswood Limited and the employees or executives. So in the general sense of making a director of Burswood Limited comfortable that there were no issues that needed to be elevated, that is the connection, that one is relying on management to provide you with assurances about those matters that make you satisfied.
Did you consider the management team of Perth Casino, or any of them, were accountable in any way, either directly or indirectly, to the board of Burswood Limited for their management of the Perth casino
They were
operations?
accountable to do the right thing as directors of their own subsidiaries and indeed in their roles as executives.
They were accountable to the Burswood Limited board to do the right thing.
Correct.
Now, at 24, you've made this point before, I think, of your witness statement, you mentioned that a majority of the senior management team at Burswood also held senior positions at Crown. You mean at CRL level?
CRL, yeah.
And did you consider them to be primarily accountable to CRL rather than Burswood Limited?
Correct.
And were there any of the senior management who you did not consider to be accountable to CRL?
I wouldn't be able to differentiate at this point who those people might be. It evolved over time.
Was the board of Burswood Limited responsible for or have any involvement in regularly reviewing the performance of the senior management team who managed the Perth casino operations?
No, because they didn't employ any of them.
Did you regard it as the responsibility of the board of Burswood Limited to in any way challenge the senior management of Perth casino and hold that senior management to account?
In the context of the way that the reports were discussed at the board, there was the opportunity to test the veracity of what was coming. And from time to time there would be Q&A about a particular matter. It might be to do with CapEx or whatever, but in the context of receiving a report and discussing it, I don't recall the need or any stage the pushing back, if you want to use that term, or not believing what was being presented to that board.
So I'll just be clear, my question wasn't directed to whether you did test management or whether there was an opportunity to test management. My question is, did you regard it as a responsibility of the board of Burswood Limited to challenge the senior management of Perth Casino and hold?
Only if there were cause so to do.
By which you mean if you saw from what was reported to you something of concern in relation to the operations?
Indeed. So the data points that we had, amongst other things, were risk management reports, specifically around things like AML, CTF, things like responsible gaming, those sorts of things like CapEx on major projects. There were data points like internal audit reports, like reports from management about interaction with Austrac and GWC, and there was reports from Ernst & Young. And my recollection is for the very substantial period of my directorship of Limited, there were no red flags raised in any of those reports that would have given me cause to challenge management.
But had there been, you would have.
Had there been, I would have probably, I'd imagine, taken it up not so much with management per se, but with CRL.
Did you regard it as a responsibility of the Board of Burswood Limited to instil in senior management a culture of acting lawfully, ethically and responsibly in relation to the Perth casino operations?
Yes.
Coming back to paragraph 18 of your witness statement on page 0004, that second sentence I took you to a moment ago, where you say you relied on and had a high degree of trust and confidence in the management, etc.
Correct.
For what purpose did you rely upon and have trust and confidence in the management team?
For what purpose? Well, what were the data points that gave me that confidence?
For what purpose
Oh,
did you rely upon and have trust and confidence in that management team?
to ensure that the operations were being conducted legally.
Right? And if during your tenure as a director you felt you couldn't rely upon or have trust and confidence in that management team, what would you have done?
I would have elevated it to the chair of the company,
Do you mean CRL?
CRL. Bear in mind that the chair of CRL for a substantial period of my directorship of Limited was in fact the chairman of CRL.
You mean James Packer?
Well, and then subsequently John Alexander. So this, I guess, is the point, that there were people in very senior roles sitting alongside me as a director who were in a much, much stronger position to determine whether management could be relied upon.
But you accept, obviously, that as a director you have independent responsibilities.
Absolutely,
Yes.
but you know, in the same case as CRL itself, when I joined that, one is given some comfort by the experience of the directors that already sit around the table. And indeed, in the case of Limited, that those people had much, much broader roles and therefore insights into matters that Limited wouldn't have had. So therefore, one, to a significant degree, relies upon your fellow directors.
Well, it doesn't abrogate your
No,
responsibilities,
not at
though,
all,
does
I'm
it?
not saying that.
So if you have a concern and you think, well, someone else at the table might know more about these things than me, you'd accept it's your responsibility to, at the very least, raise it with them.
Indeed, to the person sitting metaphorically to my left or right, who happens to be the chair of the company, the main company, my point is that at no stage in that period that I refer to were there concerns because of the documents that were coming through for our review.
But just to be clear, given that you've accepted that you would have a responsibility to raise your concerns, why did you think you had that responsibility?
Well, I'm required by the law to conduct my directorship, if you like, or my oversight of Limited in a manner that is lawful, is considered, is diligent and is in the best interest of the shareholder. And I say shareholder because there was only one.
And in relation to the state of Western Australia as well.
And in relation indirectly to the state of Western Australia, yes, not having any direct relationship with that.
Well, there's the state agreement. Can you recall whether Burswood Limited is a party to the state agreement?
It would be, as far as I recall. I haven't refreshed my memory about that.
So there may be more of a direct relationship in some respects.
I suppose the company that is actually the licensee has direct, I would have thought, more direct responsibilities than Limited.
Right, now I'm going to change topics now and I want to talk to you about risk management and go to page 009 of your witness statement where you have a heading just before paragraph 41 where you talk about risk management at the Crown Group. You see that goes through to paragraph 50 and then over at page through to page 50. Now, can I just make sure that I understand the effect of your evidence between paragraphs 42 and 44 on page 0009? Are you saying that the Board of Burswood Limited did not have any involvement in overseeing the development of the risk management system with respect to Perth Casino?
Correct.
That was effectively overseen by the Risk Management Committee, which was a committee of the CRL board.
There was a committee called the ERCC, the Executive Risk and Compliance Committee, which was a committee of either limited or nominees. I don't have that in front of me, which was responsible for the development of risk management protocols, which, as I understand it, and I didn't sit on that committee, liaised with the risk committee of CRL and other members of the board.
Right, we'll come back to the ERCC in a moment. I'll ask you some more questions about that in a moment. But I was asking you about the actual development of the risk management system for Perth Casino. Burswood Limited had no oversight of that, no approval of that system.
I referred earlier to the term adoption, recommend, those sorts of words that are in the minutes. So a risk management structure would come to Limited and be, in a sense, ratified or approved for adoption by other entities. But it had no part in the development, or the non-management directors had no part in the development of that.
But it was expected to review the system and satisfy itself that it was appropriate for Perth Casino in order to recommend to others to approve.
To recommend to others to approve, and taking into account other inputs, including, as I've said, things like reports from internal and external auditors.
So what about, we've just talked about developing the actual system itself and embedding it. What about the oversight of implementation and compliance with the system?
So, again, there would be regular board papers. The quarterly board meetings that Limited had would include a number of matters to do with risk, matters to do with compliance, matters to do with, as I said, finance, the actual operations of the business, and they would be discussed either in length or, in less length, depending on whether there were any items specifically to be drawn to our attention.
So, do I understand then that because of that recommending power that you describe and function, that Burswood Limited board did have the power to influence the content of the risk management system for the Perth Casino operations?
Well, you refer with respect to recommendation power. I think I wouldn't say a recommendation opportunity is a power. I would say it's just that. And in fact, if other parts of the organisation decided not to adopt a recommendation that Limited made, they obviously had the power to remove the directors who were responsible for that. So I guess my point is, we had, and I've indicated a number of times, papers coming to us for our review and either our recommendation or noting as distinct, depending on the circumstance.
Do you consider that Burswood Limited board had any capacity to influence the content of the risk management system and processes insofar as that applies to Perth Casino?
Only after the fact.
Did you have any concerns about that, that risk management of the Perth Casino operations was occurring primarily at parent company level or group level?
No, in fact, if you think about it, it's probably better that there's oversight at parent company level than at deep in the subsidiary level, because ultimate obligation of the directors is to the shareholders of Limited in every respect.
Well, there's also these responsibilities to the state of Western Australia that you've identified, aren't there?
Indeed, indeed.
Did you ever have any concerns that the parent company might look at risk management and identification more generically, or with a focus on the risks at Crown Melbourne, rather than considering risks specific to and in the context of the Perth casino operations?
I didn't delineate because I would have thought that it's fair to say or observe that the risk issues that might be to do with Melbourne would be pretty much the same in Perth.
Well, what about the responsibilities to the people of Western Australia?
Well, they're expressed through the operation at board level of the company. And as I've said at the outset, and I've said it many times, there were no red flags or concerns raised by the board on which I sat that there were any issues to be concerned about. As I said, the chair of the company sat on that board most of the time, and one would have imagined that if there were concerns, we would have talked about it.
So you never thought at any time during your tenure as a director of Burswood Limited, or CRL Limited, CRL, I beg your pardon, and it doesn't occur to you now that it would be preferable for risk management to be overseen locally by Burswood Limited in respect of the Perth casino operations?
I think that I would separate out my views once I became a director of CRL from my observations at Burswood Limited, and it has to do with the events that occurred at CRL level, which are well documented. I think that that's a matter for this commission to determine whether, in fact, there are flaws in the structure that need addressing, and I'm here to try and help with that.
Right, so is your evidence that looking back now with hindsight, it would be better for the risk management system for Perth casino operations to be overseen and governed locally by a local company rather than I'll just finish.
Sorry.
By the parent company?
If it's determined that there are matters that concern the government about compliance shortcomings or oversight shortcomings, then they need to be addressed. My point is that during my tenure as a director of Limited, no issues to do with that were raised. Now, subsequently, there have been obviously matters that have been well publicised. So my position would be to investigate what governance shortcomings there may have been and address them.
But you had a role to act proactively, didn't you?
Indeed. And on CRL, that's what I was there to try and do.
So would you accept that it was a governance failure of the board of Burswood Limited generally, and you as a director specifically during your time, not to appreciate a need for risk management in respect of the Perth casino operations to have an oversight component that was local?
No, because there was an oversight component that was local.
And where was that?
That was at nominees. And indeed through the directors of nominees and through, as I said, I think at least at part of the time, Mr. Alexander, the chair of the company, sat on the nominees board. So it's not as if there isn't oversight at both the parent and local level.
But Mr. Poynton, the nominees board is an executive board.
Yes.
So that's the executive governing the executive.
No, it's actually the liaison or the relationship you're talking about is in risk management back to, say, the state or the licence. You know, so, as I said, from my point of view, I'm just trying to make the point that there was no issues that came to the board on which I sat that would cause me to be concerned about governance oversight.
But that's a reactive posture, Mr. Poynton. We're talking about what you, as someone with an oversight responsibility, ought to have done. And ought you not to have appreciated that there had to be some independent oversight of management in relation to the risk management processes and systems in respect of the Perth Casino?
I would say that responsibility sat with the chair of risk committee at CRL level, the board of directors of CRL, and ultimately the chair of the company.
Are you adopting a position that it's really everyone but you had a responsibility in relation to the Perth Casino operations oversight?
Not at all. What I'm trying to say is the legal structure of this company and the way that the limited board was set up, where it didn't have any employees, it had one shareholder and had one asset, is not the normal environment that one might see in other places. It's a subsidiary arrangement, a wholly owned subsidiary. in sitting as a director of that subsidiary, one of course relies on management, on fellow directors, and on the risk management structure to be effective. And for the vast period of the time I was on the board, in my view, it was.
But it had unique responsibilities, the Perth Casino licensee, didn't it, to the state of Western Australia? Didn't it?
It had broad responsibilities and no power.
Sorry, the Perth Casino licensee had special responsibilities to the state of Western Australia, didn't it? The
Nominees.
The licensee, the nominees.
Yes, it did.
And who was overseeing it at the local level in relation to those responsibilities?
Limited was receiving information from committees and from executives upon which it relied to assume, in my view fairly, that there were no issues that Limited should be concerned about. So there is an oversight, but it's a very limited power. And of course, as we've said, if there were flags, you would refer them elsewhere, either to the chair of risk or chair of audit or elsewhere in the board. But
Just to come back to my question, Mr. Poynton, in relation to the licensee, who was overseeing its fulfilment of its responsibilities, who was overseeing it locally?
Limited had some oversight, but no power to direct.
I'm going to come to those the ERCC committee that you mentioned a moment ago. So I think you'd already said that there were no board committees of Burswood Limited during your tenure. Instead, there was this ERCC, wasn't there? Which is the acronym for Executive Risk and Compliance Committee.
Correct.
And that was formed in around May 2008, wasn't it?
I can't recall exactly when it was
Does that
formed.
sound about right?
As I said, I can't recall.
And it had a director of Burswood Limited on that committee, didn't it?
It may have had more than one. I'm not sure at a particular time.
Well, it was usually the CEO, wasn't it?
Well, certainly at one stage I recall Mr. Alexander was on it, who was both the chair, the executive chair of the company, and on Limited and on nominees.
But it was populated exclusively by people with executive functions.
Correct.
Was the ERCC established at the instigation of the Burswood Limited board?
No,
Was it at the instigation of CRL?
I don't know. I was not on the board of CRL when it was established.
Did Burswood Limited approve or recommend the establishment of the ERCC?
Not that I can recall.
Can we go please to document CRW 700.023.0324, which is the ERCC Charter of November 2010. Do you have that on your screen,
I
Mr.
do.
Poynton? And do you agree that it is a charter that applies to and is intended to apply to the ERCC and Burswood Limited? You see the reference there in numbered paragraph 2 towards the top of the page at about point 2 to the capital C company. Do you understand that to be a reference to Burswood Limited?
There is reference to the board of directors in the section purpose. It doesn't say which board.
We'll have a look at numbered paragraph 1.
Burswood Limited.
Company.
The business operations of Burswood Limited. Well, Burswood Limited didn't have direct business operations. Its asset was one share or shares in the property trust. So business operations, I would have thought, is just that, where there's a number of employees and there's operations and those sort of things. Burswood Limited did not have operations in that sense.
Well, you understood the ERCC Charter and the ERCC structure itself to be premised on the concept that Burswood Limited was responsible by way of oversight and management of the Perth casino operations, wasn't it?
So, as I said...
Just answer the question.
Sorry, what was the question?
You understood, didn't you, that the concept underpinning both this charter and the ERCC structure itself was that Burswood Limited, and more particularly the board, had responsibility for overseeing the operations of the Perth casino.
It didn't have direct responsibility for the oversight of the Perth casino. As I said, it had no capacity to direct. So it was a company in the chain. So yes, I'm not trying to deny that there was any connection around these companies, but we had an oversight role, as you've said, but we're unable to direct. So the ERC was designed to give comfort to not just this board, not the limited board, but presumably the head code, CRL board, that matters of risk were being assessed, discussed and referred.
In any event, having regard to those numbered paragraphs there, Mr. Poynton, you would accept that the board of directors of Burswood Limited had a responsibility to provide oversight for the identification and evaluation of material risks involved in the operation of the Perth casino?
It reviewed work the ERCC did, which was referenced up to the board packs and meetings that occurred quarterly for review and adoption and recommendation. As the non-management members of Limited had no involvement, it's a question of the words. We, by all means, reviewed the work of the ERCC as it came up to Limited and indeed recommended adoption in various places and times of the work that had been done. But it was not, certainly I wasn't directly involved at all, because I wasn't on the committee, of the establishment of those issues.
So if we just take numbered paragraph 1.
Yes.
And we interpret business operations of Burswood Limited to mean operations of the Perth casino. Does numbered paragraph 1 correctly state Burswood Limited's responsibilities?
Well, as I said, I think it's reasonable to potentially say that the word Burswood Limited shouldn't be there. It should be Burswood Nominees Limited.
So you've obviously seen this charter
Well,
before.
it's November 2010, so it's 11 years ago.
Have you seen this charter before?
I imagine I would have. I can't remember specifically when, but I think it was tabled, so presumably I did.
You understood the ERCC reported primarily to the Burswood Limited board?
The ERCC at no stage presented minutes of its meeting to the Limited board. As I said, what would come up to the Limited board was legal and regulatory and compliance.
Did the ERCC report to the Burswood Limited board?
Not directly.
Did it indirectly?
Only through the reports that the board got under the title Legal Regulatory.
Right. So ERCC provided reports to the Burswood Limited board, but that wasn't reporting. Is that your evidence?
Well, I'm trying to explain the way the work of the ERCC was presented to Limited. So the ARCC, consisting of executives, worked up, in conjunction presumably with the rest of the company, risk matrices and issues on risk, and gave a report to Limited.
And somebody spoke to those reports in Burswood Limited meetings, didn't they?
They would have, yes.
Yeah. And that's reporting or not reporting to the Burswood Limited board by the ERCC? It's
not. So it was not reported to in the context of someone being the chair of the ERCC. It was provided as a report on risk matters, but it wasn't like in other boards you get the minutes of the risk management committee or the audit committee, and there's someone, the actual chair of that will report on that. that was not the context in which these reports were given. They were not given as minutes of the ERCC to us.
What do you think you had to do with the reports once you received them?
Study them, I guess, satisfy myself and the rest of the board, presumably satisfy themselves, that there were no issues that needed escalation.
Right? And if they did need escalation, what would you do?
Well, they didn't, so there was not an example of that. If, in fact, hypothetically, they had needed it, the first person one would have spoken to was the chair of the company who sat on Limited. And as I said, you know, the chairs were the ones that set these things up.
So this charter...
Sorry, when you say the chair of the company, do you mean the chair of CRL or BNL?
CRL.
So this charter that's on the screen, Mr. Poynton, the ERCC charter, was that ever formally adopted or approved by Burswood Limited?
I assume it was.
And by you? You approved it in your capacity as a director?
I
Thank you, Mr. Poynton.
Thank you.
Ms. Cowan.
Thank you, Commissioner. Now, Mr. Poynton, just so that we can get some understanding of the general procedures of Burswood Limited Board, you mention at page 0006 of your statement, at paragraph 29, put that up on the screen for you, that before each meeting the directors were provided with board packs, and you described there in the subparagraphs topics that are fairly conventional that you would normally see in professions around funding.
Yes.
Now, if we go to CRW.702.001.1322, this is just an example board pack, and that I'm going to ask to be put up on the screen for a meeting that was to be held on the 13th of August 2013. Now, you've mentioned elsewhere, I think at paragraph 15 of your witness statement, that your board packs at Burswood Limited did not include minutes of Burswood Resort Management meetings or Burswood nominees
Not as
meetings.
far as I recall.
Do you think your board packs should have included those minutes?
Yes.
Did you ever raise with anyone we
No,
should have these minutes?
So, again, it's a hypothetical question. Could have they? Yes, they could have.
Sorry, I'll just correct you. I asked, do you think they should have?
Oh, sorry, I apologise. I heard could. I had no cause to believe they should, in the sense that I thought the information that I was receiving was sufficient for me to understand the issues. Perhaps best practice might suggest they should have been, but I'm not suggesting that.
Do you know if any other company in the Crown Group routinely received the minutes of meeting of the licensee and or the manager of Perth Casino, other than those companies themselves?
No.
Do you think somebody other than Burswood nominees and Burswood Resort Management should have received the minutes of their meetings?
Yes, they should have, and I'd imagine that that would be the risk committee of CRL, a matter I would have thought for discussion with the chair of that committee, or indeed the chair of the company.
Not something that you ever checked?
As I said, the information that I was receiving was sufficient for me to form a view that there were no red flags requiring my intervention.
What I'm putting to you is, did you ever check to see that those minutes were being sent to CRL?
No.
You should have, shouldn't you?
No, I don't believe I should have.
But Burswood Nominees and Resort Management were the subsidiaries of Burswood Limited.
Over a period from 04, my position would be that were I to form the view that I was not receiving sufficient information, then I would have, I'm sure, taken it further.
Well, let's take that in steps. I'm asking you about the minutes going up to CRL.
Yes.
You didn't know whether they were going up there or not.
No, but I assumed they were.
Right. Why didn't you check?
I suppose for the reason that I had no cause to be concerned about the quality of the information coming to me as a director of Limited.
Well, let's talk for a moment about the information you were getting in your capacity as a director of Burswood Limited. Wouldn't receiving the minutes of Burswood Nominees and Burswood Resort Management meetings have given you an opportunity to cross-check and verify what you were being told?
It would have.
And wouldn't it have been good governance practice, therefore, to require those minutes to be provided to the Board of Burswood Limited?
It would be enhanced governance. I suppose where I'm coming from here is that I was a director. Sitting alongside me was the chair of the company. They had purview, they had control over the flow of information. And so I would say that I was satisfied, and I'm assuming because there was no other intervention, that the chair of the company was satisfied, and because there was no other intervention, the chair of risk at CRL was satisfied. So my point the whole time is that where I had reason to be concerned, I would have escalated matters. The structure of the receipt of minutes, etc., which maybe in hindsight have been better governance to receive, and I'll concede that, the absence of those minutes coming to the board on which I sat did not give me cause to be concerned about the quality of the information.
When you say you look back in hindsight and it would have been better governance to require those minutes to be provided to you, were you at the time, when you were a director of Burswood Limited, effectively refraining from asking for the minutes because you relied on the chairman and what the chairman's disposition to governance requirements was?
So I would have been, as I've just mentioned, satisfied about the information received.
You weren't checking it. This was a cross-check, wasn't it?
Well, I'm not sure, with respect, what would have been in the minutes that would have been different from the reports that were coming up from risk and legal.
But you never looked.
No, I was never given the opportunity to look, and I was never given reason to be concerned about it.
Well, what do you mean you were never given the opportunity?
Well,
all you needed to do was ask. Isn't that so?
The reason I didn't see them was because they were not provided. As I've said, if I had cause to be concerned about the quality and veracity of the information coming to me, I imagine I would have asked for more information. There was no reason for me so to do, and there was no reason, as far as expressed or not expressed in a way by the chair, for members of that board of Limited to be concerned.
Now, presumably you read the board packs before each meeting.
Yes.
They related to.
Yes.
And meetings took place for Burswood Limited on a quarterly basis, didn't they? 4 times a year.
Correct.
Yeah. Did you consider at the time that the board should meet more regularly?
I didn't consider it at the time, as is in my evidence subsequently when I became chair. It struck me that the meetings could occur more frequently and have more information, particularly from a group level, provided to them. as I've said, the structure of this was set up by initially James Packer and then other chairs along the way, mostly John Alexander. And again, given the roles and responsibilities we had, which in my view were quite limited, the information coming quarterly was sufficient.
Although it was a monitoring and oversight role, wasn't it? Wasn't it?
Correct.
And in any event, your position is that at the time it did not seem to you that you needed to meet any more than quarterly.
Correct.
Now, we just have a look at this document. This is an aid that we have prepared, Council assisting and the legal team for the Commission have prepared, and it's derived from the minutes of meeting of Burswood Limited. I'll show it to you, pcrc.007.001.001. And what it does, Mr Poynton, is it records the time taken for board meetings of Burswood Limited, the length of them between 2009 and 2020. Now, there's some summary information on this front page, and we can see, do you see that average column, the second last column on the right-hand
Yes.
side? The average length of meetings each year. And all of them are under 1.5 hours. You see that?
Yes.
And then if we go into the detail over the page, you'll see that we've got the times taken for individual meetings. If we can go down to 2013, please. (2013). Right, thank you. And you'll see there for July and August 2013, the meetings last 26 minutes each, and then for October 2013, 34 minutes, and then if we go over the page, for December 2013, 28 minutes. Now, Mr Poynton, was it the case that until the Bergen inquiry commenced, the Burswood Limited Board was not giving any detailed consideration at meetings to agenda items?
Sorry, can you ask
Until
that
the
again?
Bergen inquiry commenced,
Yes.
is it the case that the Burswood Limited Board was not giving any detailed consideration at its meetings to agenda items?
The Board of Burswood was not giving consideration to its agenda items.
Any detailed consideration?
Or any detailed, sorry, I apologise. No, I think that I would say that the packs were sufficient to get a clear understanding of the issues. And indeed, opportunities arose prior to the meetings for interrogation of the other directors, being people like John Alexander or Rowan Craigie. And so I think that the board did give consideration to the matters, but it was more in the context of things taken as read, and if there's a matter to discuss, it would be raised as a result of that, as distinct from a whole lot of time being spent, as in some board meetings in other companies, people speaking to or going to detail about things that have already been presented in a pack.
Well, what I'm trying to ascertain is how much discussion, debate and interrogation of management issues was conducted at board level.
Right.
And before Bergen, the answer is not much. Isn't that so?
Well, I think I would accept that the duration of these meetings, certainly on comparison with an operating board or a company with a board that has operations, these meetings were short in duration, for sure.
Because it didn't have operations?
Well, partially because it didn't have operations, partially because the chair decided the length of the meeting. In various cases, whichever chair that might be, you're sitting as a director on the company, apart from the opportunity to ask questions, which the minutes reflect I did from time to time, one doesn't, as a director, set the duration of the meeting.
But what do you mean by that, Mr Poynton? That if we take the 12 December 2013 meeting on the screen, that when it began, the chairman said, well, we have half an hour today.
No, it wouldn't be set at a particular time. It'd be whether the meeting conducted itself and reviewed the matters on the agenda, which would determine how much discussion and therefore the duration of the meeting. It wasn't at the start, oh, this meeting is going to take 28 minutes.
But you were a director with independent responsibilities, yes?
I had responsibilities along with the rest of the directors on that board.
But if you wanted to discuss something or debate it or interrogate it, it was your duty to raise that, wasn't it?
Yes, and I did from time to time,
All right.
as the minutes reflect.
And I just want to go back to something you said a moment ago. Is it your evidence that you would debate issues with directors or the chairman outside of meetings?
Not debate, I wouldn't use the word debate, discuss, get context, have a sense of the overall direction of the business. So there are obviously opportunities to discuss formal things and informal things, both, in the meeting in the case of formal and outside of the meeting in the case of informal. It's part of what a director does to inform themselves.
Right now, if we
Just,
go...
just while we're on that, those discussions, were they frequent, infrequent, the discussions before meetings or
Commissioner,
outside
so
meetings?
in most occasions, Mr Alexander in particular, not so much Mr Packer, would come over to Perth the night before the meeting and would generally arrange to have dinner with me and or other directors, at which the forthcoming agenda items would be discussed in either some detail or generally.
Now, Mr Poynton, if we go back to your witness statement at paragraph 31 on page 0006 and at 32 at 31, you refer to your appointment as Chair of Burswood Limited in January 2020 to replace Mr John Alexander. And before then, as I understand it, Mr Packer was Chairman from 2004 until 2016.
Correct.
So we have Mr Alexander there from 2017 until 2020.
Indeed.
Were there differences in how each of them performed the role of chair?
I would say yes, in the sense that Mr Packer was obviously a very busy man in the context of all the other things that he was doing, and therefore was probably in a way almost more like a non-exec chair in the way that he was involved, whereas Mr Alexander was clearly executive chair of CRL and indeed on a number of these subsidiary boards that we've discussed, and therefore had a much more active role, integrated role.
How did that translate into how the board meetings were conducted?
Well, it may not in fact show much difference in the way that board meetings were conducted, but as I said, the opportunity to have conversations with Mr Alexander before meetings were things that didn't occur necessarily and in the same frequency as perhaps with Mr Packer.
Now, in paragraph 31 of your witness statement, when you're talking about when you assumed the role of Chair of Burswood Limited, you talk about identifying that there should be a stronger information flow between Crown and Burswood. You mean a stronger information flow from CRL to Burswood
Correct.
Limited and not the other way around?
Correct.
So you understood that monitoring and oversight role that Burswood Limited had in relation to the Perth casino operations, at least by 2020, required the Burswood Limited board to have more information.
My position was, and obviously from, say, pick a time, but from the 60-minute allegations onwards and through the subsequent Burton inquiry and then into COVID, there were a number of matters that were very relevant to the operation of the Perth property or the Perth business that the board of Burswood Limited should have and would like to have more information on, i.e. what's happening with, say, our response to COVID, or what's happening with our response to the allegations or whatever. So whilst not necessarily specifically within the purview of Burswood Limited, I thought that particularly for Ms Fewster, who was a relatively recent appointment to the board, that whilst I was able to get quite a lot of information from my role as a non-exec director of CRL, she was not in that same position. So it seemed to me that providing her with that additional overview would be helpful.
Now, at 32 on page 0007, paragraph 32 of your witness statement, you say that as chair, in terms you thought there should be more detailed briefings and increase the frequency and duration of meetings. Was that something you identified just yourself, or was it reacting to complaints that Marina Fewster had made about the length of board meetings and their frequency and the amount of information that was being provided?
I recall it being my initiative. I don't recall Ms Fewster complaining about any lack of information or the duration of board meetings. I made the decision to have more, 6 not 4, and to have more information coming from CRL. But I don't recall that being in response to any complaints Ms Fewster made. You can ask her. The problem was that I was appointed chair in January 20, and we all know that COVID arrived in February 20, and whilst I think there were 5 board meetings with me as chair, there were complications around actually physically meeting. The property was shut for a few weeks, and so the best laid plans. So I was keen to have more frequent meetings, particularly during a period where the company was facing so many issues on so many fronts, including the operational issues around COVID.
In terms of the duration of individual meetings, in general terms, you increased the duration from what to what?
Well, I'm sure that the records are there, but from, half an hour, shall we say, in some instances you've identified, to more like an hour, hour and a half. I'm not sure specifically, but the minutes will also reflect that there was a greater level of information that was discussed and therefore minuted. In fact, I think it's in the records, but the minutes of the meetings I chaired were significantly longer than the minutes previously. Now, I'm not making criticism about that, it's just a fact.
Well, the 1 to 1.5 hours, let's stay with that for a moment, that the meetings became from the time of your chairmanship, did you think that was sufficient to address the issues that fell within the Burswood Limited Board's remit?
I think so, yes. I mean, one can always be told they can improve. But my view was that we were discussing the things that needed to be discussed. As I said, they included issues nationally, but issues that had reputational impact to Burswood Limited. So I was keen to make sure that there was more activity at that level.
Now, just to be clear as to the effect of your evidence, this instigation of yours to increase the frequency and duration of meetings and the amount of information that was provided, was that a reaction to the issues, the particular issues that arose in 2019, 2020?
Or 2018 onwards.
Right. Or was it also, or separately, because you thought previously there wasn't enough time and information provided in relation to meetings?
If I had to weight it, I would say 80-20. 80 that there was a significant number of new issues the company was facing. As I said, not just regulatory and reputational, but operational. And bear in mind that the company employs however many people, 16,000, 17,000, and 5 in Perth. We were very concerned about the issues to do with the operation here. And then the 20% would be conceding that, I suppose in the back of my mind, as a director, minutes or indeed meetings could have been longer.
With more information?
Well, more discussion of the information provided, I suppose, rather than, as I said earlier, just taking things as read. But again, it's not in the context of there being any specific concerns, whether it's from the auditors or the various consultants that were providing information. It was more just making sure that everyone was comfortable that there was an opportunity to discuss everything.
As to that 20% that you've just identified, you had been on the Burswood Limited board some 16 years, hadn't you, before you became chairman?
Yes, it was from in 04 to the start of 20.
And you hadn't raised that 20% concern with the then chairman, or chairman in the plural, any time during those 16 years?
Not formally, no.
Do you accept that you should have?
I would say that if there were cause to be concerned that the duration of the meeting was leading me to be under-informed or not having the opportunity to properly discuss matters, I would have and should have raised it and asked for the meetings to be longer. What I'm saying is I didn't form that view. It was a nuance.
So that 20% concern you had about the duration and content of the meetings previously was a nuance.
Well, what I'm saying is that you're using the word concern. I don't think I had a concern. You asked me whether I felt there was a problem with the duration of the meetings. I guess as chair, I'm trying to make sure that my fellow directors, particularly the non-exec director, feels that they have sufficient opportunity to raise whatever issues. From my point of view, in the 16 years, I felt I did have sufficient opportunity to raise any issues that might have caused me concern.
Prior to 2020, did you, when you were attending a board meeting of Burswood Limited, did you ever witness or participate in detailed discussions with management, the board interrogating reports that had been provided to it?
There was discussion with management about items of interest in the board packs with management. I mean, there are two non-exec directors and the other non-exec director didn't always attend, so, Pridem is Fuster. But there were, and I think the minutes reflect, discussion with management.
What I'm talking about is pushback and challenging and interrogating, and rather than just asking for more information or agreeing with or noting what management has reported.
Yes, there would have been, and I can't recall particular circumstances where there would have been more interrogation, using your word. Not so much pushback, but certainly requests for more information from management.
Did that happen frequently?
Not that I recall, no. And again, as a director, one is in the hands of the chair, who's the executive chairman of the company. So I keep coming back to that because I think it's actually important.
When you say you're in the hands of the chair, what do you mean by that?
The chair of a company has significant power, whether they be the chair of a particular subsidiary or indeed the chair of the whole company. So the chair sets the cultural, the risk tolerance and the leadership of the company, and then it's expressed through the board into management. So there's only certain things an individual director can do. I'm saying that I was not given cause to be concerned about the level of information, but the structure, the length of the meetings, those sorts of things, very much in the purview of the chair. When I took the chair, I changed it.
Your duties as a non-executive director are neither curtailed nor subordinated to the duties of the chair, are they?
No, they're not.
Did the board of Burswood Limited ever take advice outside of management regarding the establishment and implementation of an appropriate corporate culture for the Perth casino operations?
Sorry, not that I recall at Burswood Limited level. Certainly CRL has, as my recollection, sought advice about culture.
Did the Burswood Limited board ever have strategy days, retreats or the like independently of management for determining the strategic direction, risk management or ethos of Burswood Limited?
No.
Did you ever conduct your own inspection of the Perth casino operations without notice to management?
No,
For example, did you ever appear unannounced one evening at the Perth casino to observe a junket tour in operation?
no,
Did you ever appear unannounced at the Perth casino to observe the operation of the cage,
no,
the Pearl Room?
no,
Did you ever attend at the Perth casino unannounced to observe the operation of the EGMs and table games on the main gaming floor?
no,
Do you know if any of the other directors of Burswood Limited ever conducted such unannounced inspections?
no, I don't know.
Do you think they should have?
You think they should have?
Yes.
Well,
Do
it's
you
up-
think any other director should have?
Well, it's up to them to say what they thought they should or shouldn't have done.
Asking for your opinion.
No, I can't presume to say what another director should or shouldn't do.
Do you think that any other director of Burswood Limited should have made an unannounced inspection of the Perth casino operations?
No,
Do you think you should have?
no.
Now, I'm going to move to the topic of anti-money laundering and counter-terrorism financing issues, which you talk about between paragraphs 100 and 132 of your witness statement. That's pages 0025 to 0034. Now, Mr. Poynton, you were no doubt aware from about 2006 of the introduction of the Anti-Money Laundering and Counter-Terrorism Financing Act.
Yes.
Did you familiarise yourself with that act at the time?
I beg your pardon, sorry?
Did you familiarise yourself with that act at the time?
Not in a specific sense, but generally made aware of its existence and its fundamental thrust.
When you were a director of Burswood Limited, who did you understand to be the relevant reporting entity under that act in respect of the Perth casino operations?
CRL.
Why do you say that?
It's the head company, it owns the assets and is responsible for the operation of the business.
At paragraph 100, which is on page 25, you see that second sentence?
Yes.
Where you're talking about a situation from around 2017, where you were focusing on, or the board was focusing on improving, both boards focusing on improving compliance with AML CTF. You see that?
Yes.
I want to come back to that in a moment, but first of all, I want to ask you some questions about the period between the introduction of the AML CTF Act in 2006 and 2017, so before it became a major focus. Do you understand the time period I'm talking about?
I think so.
During that period, did Burswood Limited Board, as far as you understood, have any responsibility for or involvement in overseeing compliance with the AML CTF Act by the reporting entity for the Perth casino operations?
That's from the period of the Act being promulgated, you mean?
Until 2017, that's right.
My understanding about the interaction of the Burswood Limited Board was that it was keeping a very close watch on. I'm just not sure. I want to answer the question properly.
Shall I ask it again? Would that help?
I think that would help,
Yeah.
just the oversight.
So between 2006 and 2017, did Burswood Limited Board, on your understanding, have any responsibility for or involvement in overseeing compliance with the AML CTF Act by the reporting entity for the Perth casino operations?
It had oversight again, and as I said, the board packs included substantial, as it turned out over time, reports about compliance with AML CTF as it evolved, and it evolved and continues to evolve over time.
Did on your understanding for that same time period, did the CRL board have any responsibility for or involvement in overseeing compliance with the AML CTF Act by the reporting entity for Perth casino operations?
I would imagine absolutely.
Well, you imagine. What did you understand?
Let me repeat. Yes.
And how did you arrive at that understanding?
I arrived at the understanding because, and I've mentioned it a few times, they own 100% of the assets and ultimately are responsible for the interaction with the government through the licensee wholly owned subsidiary.
Now, I've just been asking you about responsibility for overseeing compliance with the Act,
Yes.
the statute.
Yes.
In that same period between 2006 and 2017, did Burswood Limited Board, on your understanding, have any responsibility for or involvement in overseeing the implementation of risk management systems to address the risks of money laundering occurring at the Perth Casino or through its operations?
Yes, so the Burswood Limited Board received numerous reports about compliance with AML, CTF and more broadly money laundering requirements over an extended period, and including, things like external auditors reviewing these matters and not flagging any concerns at all.
Now, did CRL have any responsibility for overseeing the implementation of the systems and processes to address the risk of money laundering occurring through
Yes.
its operations? And what was that responsibility?
As the owner of the assets and ultimately the owner of the wholly owned subsidiary that had the connection with the government, it had primary responsibility for the compliance with those requirements.
Now, the respective responsibilities in relation to AML, CTF that you've just described to me, Burswood Limited on the one hand and CRL on the other, were they documented anywhere?
The only documentation was in fact the reports coming through. There was no delineated, well, this company's responsible and that company isn't, or they're both responsible.
Do you think there should have been a document that delineated the roles of each?
It's hard to answer because if I were concerned that there was a problem, then presumably documenting these things, if there were any concerns about who was responsible for what, might well have helped, but there wasn't. So it wasn't something that I thought, well, we really need to write down the delineation, because everyone had AML, CTF front of mind, both from the Burswood Limited point of view and later on for me, CRL.
Now, over the page 0026 at paragraph 103, you mentioned that the AML CTF program for Crown Perth, that's Perth Casino, was approved by the Burswood Limited Board on the 21st of November 2007. When you say approved, do you mean that approval to be given by CRL was recommended, or was Burswood Limited actually approving this for Burswood Nominees Limited?
Over time, when you look at the wording of the minutes, there are words like approved or delegated, but in fact, in the case of the word delegated, it had no authority to delegate to Mr. Felstead because he was not an employee. So approving, yes, we approved the program and essentially ratified what was happening elsewhere in the organisation.
Well, this is, we're not looking at any minutes, we're looking at your evidence
Yeah,
here
sure.
in paragraph 103, and the first sentence is that the Board of Burswood Limited approved the program. And you understood that that approval was required to be given before that program could be implemented at Perth Casino operations.
Yes.
And therefore you understood that the Board of Burswood Limited had to be satisfied that that program was an appropriate program to adequately mitigate the risk of money laundering occurring at or through the Perth Casino operations.
Yes.
Now, this second sentence that you drew attention to, at the time the board delegated Mr. Felstead as Burswood's CEO to make amendments to this program, that in fact happened, did it?
Well, again, looking at this word...
But it's your word, Mr. Poynton.
I know it's my word. I'm saying that in the strict legal interpretation of the legal structure of the businesses, we were not able to delegate to Mr. Felstead, so I probably should have used a different word.
What's the word you'd like to use now?
Recommended.
Recommended what?
that Mr Felsted, as Burswood CEO, made amendments to the AML CTF program.
And did he have power to do that? The program that your board had approved, he could make amendments to that, but you couldn't?
I assume he had the power to do it. He's the CEO of the company and he's presumably got some other direction from elsewhere in the organisation as well.
Well, I'm just focusing on your evidence, which
Sure.
is the second sentence. November 2007, what did the Burswood Limited board do in respect of Mr Felsted making amendments to the program?
14 years ago.
This is your evidence, Mr.
I know, but
Boynton.
it's 14 years ago. I can't specifically recall, other than saying that Mr Felsted, as Burswood CEO, was in this case delegated to. But again, I'm just saying that in the cold light of the structure of this company, we were not able to delegate to Mr Felsted. We were not able to direct to Mr Felsted. So again, the word probably should have been recommended.
You could not now think it was appropriate to confer upon any member of the executive management a power to amend the AML CTF program without reference to the board of Burswood Limited, would you?
I think what I would say is that the way this was set up was, as I've said at the outset, an oversight board, wholly owned subsidiary, and therefore had limited powers. Now, certainly as far as AML is concerned, that there was oversight of that, and the company took those issues very seriously, as evidenced by the multiple numbers of minutes. But getting back to a period 14 years ago, I can't specifically recall, other than what I've said in my evidence, that Mr Felsted would have had carriage of that matter.
Well, let me ask you what in fact happened. Did management or did management not make amendments to the program without first getting approval from the Burswood Limited board?
It appears from this, and I don't have a specific memory, that there is an approval, if you like, or a recommendation that Mr Felsted is allowed to make amendments to that program, the details of which I'm not sure. What I would say, though, is subsequently, whenever reports came back, no external or internal red flags were raised. So whatever amendments were made didn't cause an issue.
You would accept it would be a governance failure by the board of Burswood Limited to permit the program to be amended without reference to it?
I would say that depending on what the amendments were, not necessarily, because they might have been minor amendments.
Well, this doesn't specify, does it? Your
No,
evidence?
it doesn't. And maybe we need to, because that would inform the answer. It may be that the amendments were actually of a very minor nature and that was explained at the time of the meeting. It's
Well,
just that it's 14 years ago.
You give evidence of some of the amendments at paragraph 104, don't you?
That's 7 years later.
Right, and I wanted to ask you a question about that first before we go to the detail
Sure.
of this.
Yes.
Are you suggesting that this was the first time amendments were made to the program, 7 years after it was first approved?
I can't recall how often amendments were made. I'd need to refer to the minutes, but I'd imagine that were amendments between 07 and 14.
Now, this also suggests, this evidence that you've inserted here at 104, that the amendments were happening before the board was notified of them. Is that what happened?
It appears that that's what happened. But again, I would say that the material issue is whether this enhanced or didn't enhance the quality of the AML program. And on the reading of this, and I'd need to check with the minutes, it does.
So how does that work, Mr. Poynton? If the executive team unilaterally decides that something's an enhancement to the program, a measure is or a procedure is an enhancement, they didn't need to come to the board first, but if it was in diminution of the program, they did.
What I'm suggesting is, and I don't know for sure, but back then, I'm not sure how it worked as it related to CRL, but I can't imagine, and again, there was no reason to be concerned, that management was going off and doing things prejudicial in the AML program to the company. There's no evidence of that. So the nuance again of whether they were unilaterally acting against the interest or for the interest of the company is not clear, and I don't know.
But wasn't it entirely your job to sit on top of management proactively and to exercise oversight to make sure that they weren't?
And so what I would say to
Yes
that...
or no?
Sorry?
Do you agree with that
What
proposition?
I would say to that is that,
Sorry.
again...
No, let Mr Poynton answer that question.
What I would say again is that the minutes would reflect the numerous times that the Burswood Limited board discussed this, the external corroboration of there not being a problem with the AML program, satisfying me as a non-exec director alongside the chairman of the company, who's not expressing any concerns, that there was not a problem with whatever amendments were occurring. If there'd been evidence, if there'd been evidence that management's unilateral actions were diminishing the quality of the AML program and therefore increasing the risk for the company, clearly as a director, and I imagine other directors, would have intervened. There was no need for that.
Now, you gave evidence to the Bergen inquiry, didn't you, that you first became aware of the Riverbank account or counts at the time of the media allegations in about July or August 2019?
Correct.
And I understand from the opening of your council, opening statement to this commission, that you were also not aware of the existence of Riverbank Investments Pty Ltd until about July or August 2019. Is that right?
That's correct, and to my best of my recollection.
Now, Riverbank Investments Proprietary Limited was a wholly owned subsidiary of Burswood Limited since at least 2005. You agree with that?
Yes.
And you're not suggesting, are you, that the existence of that company was hidden from you as a director of Burswood Limited?
No, it wasn't hidden. It wasn't specifically referred to. And again, I'm not sure how many subsidiary companies there were of Limited, but I'd imagine it'd be more than one. And indeed, obviously, Nominees was a subsidiary company.
Mr Poynton, isn't it the case that your failure to be aware of the existence of Riverbank Investments Proprietary Limited as a wholly owned subsidiary of Burswood Limited until 2019 was a failure on your part to ask the right questions of management to hold them to account?
My response to that would be, what question would have I asked? So we rely on management to provide us with information to carry out our duties as a director. And if they don't tell us that there's a subsidiary company that subsequently is a problem, then I'm not sure, other than relying on management and fellow directors who are more deeply enmeshed in the company, what I as a director could do. And I made that point to Commissioner Bergen. How can you, if you don't know something, do you ask something about which you know nothing?
Did you ever ask management of the Perth casino operations to please provide you with a detailed corporate structure diagram showing all subsidiary entities of Burswood Limited?
No, I didn't.
You could have done that annually, couldn't you?
I could have.
And it was a serious failure of corporate governance on your part to not do that,
I
wasn't
reject
it?
that, no.
Now, you mentioned some internal audits that were conducted by Perth Casino management at paragraph 127 of your witness statement in relation to AML CTF issues. And you say you relied on both internal and external audits. Just asking you to clarify your evidence in relation to that. Was it Crown or Board who was relying on these internal and external audits, or both?
Both. Certainly in the period referred to, 2013 and up till, as we know, late 18, the comment would be around Burswood Limited. After that, Burswood Limited and CRL.
Now, at 125, paragraph 125 on page 0032, you catalogue a number of internal audit ratings from internal audit reports that were in the board papers for Burswood Limited. You see that?
Correct.
And why do you, on your understanding, why were you being given those audit ratings?
Well, I'd imagine, we'd be given them as part of our, I guess, corroboration that the company is acting, in the best interest of all its stakeholders. So we received external audit reports from Ernst & Young, internal reports, reports from third-party consultants, all building a picture around compliance.
So just in relation to the internal audits, did you understand that they were auditing and reporting only on compliance with the AML CTF program and company policy?
Well, it says so. The AML CTF audit rating is good.
Did you understand that they were, whether or not they were auditing whether those practices and policies were actually adequately mitigating AML risks in day-to-day operations?
The strict reading of the internal and audit report suggested to me that internal audit had no issue with compliance of AML CTF. That's all I can say.
But a risk management system is only as good as it is to mitigate risk, right? A poor system will not, in fact, mitigate risk adequately, will it?
I'm not sure. If you have internal, external audits and reports of third-party consultants, and there's reference to a question I asked a third-party consultant in my evidence, I'm not sure what else one can do as a non-exec. You're receiving all this corroboration and evidence from other parties, internal and external, that there is not a problem.
So just staying with the internal audits, and we'll get to the others in a moment, Mr. Poynton.
Sure.
Did you understand that the internal audit reports were auditing whether or not money laundering risks were actually being adequately mitigated in the day-to-day operations of the Perth Casino?
My understanding was that the internal audit was saying that the company was complying with its obligations under AML CTF, which I would include to be money laundering.
All right, let's go to document CRW.702.001.395.4.
Just whilst we're doing that, so I think to get back perhaps to the point Ms Cahill was making, there's a difference between complying with the letter of the law and actually mitigating the risks, adequately mitigating the risks that the law is designed to regulate. So was your understanding that the internal audit was doing the former, telling you that you were complying with the letter of the law, or was it telling you, or that they were telling the board that the risks, the actual risks, were being, in practice, properly mitigated within the business?
Commissioner, I would say both. I wouldn't delineate between one or the other. It's an overall feeling that the company is compliant.
Thank you.
Thank you, Commissioner. Now, I'm taking you to a board pack for the 15th of June 2018, and if we go to page 4018, there's internal audit activity report there for May 2018, and this was the way in which the internal audit activity was typically reported to the Burswood Limited board. Is that right?
Yes.
And if we go down to the second box, which is in relation to anti-money laundering and counter-terrorism financing, talks about key issues identified and causes, risk implications and management response. And I'll just show you over the page because that's not the complete section. Oh, yes, it is, sorry. We've got the report rating of good, yes.
Right.
Now, this obviously didn't tell you how the audit had been designed, did it?
No.
And it didn't tell you how the audit had been executed?
No.
Did you ask questions about how the audit had been designed and executed in meetings?
Not that I can recall.
That was an oversight of governance on your part, wasn't it?
I don't believe so, and I would draw your attention to the audit activity and scope in the left-hand column, which varied from good to excellent.
Yes, but you don't know what the audit entailed or how well or poorly it was executed, did you?
So there's an audit committee at CRL level, which I would suggest had greater carriage over the design of internal audit than a member of the Burswood Limited board.
So what was your oversight function then?
Well, we've talked about that.
So
I'm
not to challenge...
I'm receiving reports that suggest to me there's not an issue. I don't drill into the actual design of the audit because I'm imagining, I think with some justification, that other people are responsible for that.
But how would you know that? Did you ever check?
Well, again, and it plays to the question about the quality and competence of the other directors in the business. So if you start with a chair of audit, supposedly a competent person, chair of the company, the various other people involved in the whole process. My position is that I did not feel it necessary to drill into that level of detail. Had there been ratings other than good to excellent, I would submit that I would have.
But Mr. Poynton, you're being provided with an internal audit report for the purpose of an oversight function as to the adequacy of the AML CTF risk mitigation system. You'd accept that?
Yes.
When you are told that the audit conducted has given a rating of good to the risk management system, isn't the first thing you need to understand what the audit is, what the audit entailed, and how well it was performed? Aren't they precisely the things that you need to interrogate as a director with an oversight function in relation to AML CTF issues?
I would suggest that in the column key issues identified, there is some granularity, if you like, about what in fact the issues, the conduct, the scope of the internal audit activity report was. Again, in the absence of there being concern, I don't think my role as a non-exec director of Burswood Limited extended to drilling in to that level of detail.
So you weren't concerned, therefore, that this report might have overlooked, failed to detect other issues or more serious issues?
There was no evidence in anything I saw, received or read that would give me that concern. I come back to the fact that there are various other people involved in the chain, not the least of which is the chair of audit, who had been, as I understand it, chair of audit for some time and presumably had satisfied themselves. Now, did I specifically ask? No, I didn't, but I did have confidence in that person's ability to be on top of the issues.
Now, if you just stay with that box, in the second column, key issues identified, and do you see the third dot point, lack of an annual review over risk assessments for all designated services? See that one?
Where are we again, sorry?
Third dot point in that second box under key issues identified. See the box that says 5 minor areas for improvement? You got
Yes.
that? And then you drop down and you see 4 dash points, and I'm taking you to the third one. And
Yes.
it commences lack of an annual review over risk assessments for all designated services. You got that?
Oh, that's the third point in the left-hand box.
Well, second to far left hand.
Yes,
Second column. You got it now?
yes.
As an example of a area for improvement that was reported in one of these internal audits, how did the board of Burswood Limited oversee the response to the audit?
I would imagine, well, I can't specifically recall, but there would have been a subsequent internal audit report, which presumably would have addressed that or not. I mean, there's obviously a management response which suggests that there's a recognition that things need to change. And again, you know, the next internal audit report may or may not flag that it hasn't been done as it's supposed to have been done. I don't recall that flagging occurring. In other words, there's minor areas for improvement, which is the word, report rating good, management response, and then I wait for the next internal report.
But you carefully check against
Well,
month to month, or sorry, quarter to quarter?
Quarter to quarter, the extent to which one remembers with everything else you're doing, a specific matter, but you are given some opportunity, comfort, whatever the word is, when the next internal activity report comes along to see whether the same flag is there.
But it's not a memory test, is it? You just pick up your old board
Well,
pack with the report
sure.
from the previous quarter and you compare it to the new board pack and you check to see whether the proposal to implement an improvement has in fact happened. Did you do that?
I don't recall specifically doing that. I would have taken some comfort from the next rating.
Now, external audits, you say you also relied upon, and these commence at, you refer to these at paragraph 127 of your witness statement between pages 32 and 33, and these are external audits that happened before 2017 that you've listed there from A through G. You see that? Now, these external audits occurred on a half-yearly basis, yes?
Yes.
It's just that we need the response
Yes.
to the transcript. Thank you. Now, if we take as an example the first external audit report that you refer to at subparagraph A and pick up the reference at footnote 70, that's CRW.702.001.0964 at page 1004. So that's the page that you've referred to as an external audit. Now, if we just go back to the beginning of this report, so just, so the beginning of the report, please. So we go back to page 1004. And cursor back to the beginning of the report. Thank you. You understood this, didn't you, to be a high-level financial audit, didn't you?
A financial audit, I don't know about high level.
Well, it wasn't auditing business or operational risks, was it?
I don't know the answer to that question. I thought that it was a review of the risks or the an audit of the business.
AML risk.
No, risks generally.
All right, well, let's go to the page that you rely on, 1004. And you say that this was an external audit that gave you comfort that AML CTF risk was being appropriately managed and that the casino operator was compliant with AML CTF laws. Is that your evidence?
I would refer to, during our review, we have not identified any instances of non-compliance with laws and regulations.
Well, what were they looking at?
Well, laws and regulations is a pretty broad term, and I'm assuming it included AML, CTF and the rest of the laws and regulations that the business operated under.
Why did you assume that?
Well, why wouldn't I? The reality is it's an all-encompassing term, non-compliance with laws and regulations. So you would imagine that the external auditor, being Ernst & Young, would have actually, and it says there's full cooperation with management, no unsolved disagreements, etc. in the scope of our review.
You would have had to have at least interrogated whether AML CTF risk had been audited, and if so, how, wouldn't you, in order to be able to rely on this document?
No. I rely on the document prima facie as written.
There were more specific external audits, were there, undertaken in relation to AML CTF in respect of Perth casino operations?
It's a question of when. Obviously, subsequent to, I think, around 17, 18, there were any number of reviews conducted company-wide that would have included Burswood in the chain of owned subsidiaries.
Well, there was one in 2010, wasn't there?
Not that I can recall, but
CRW.700.019.1547. AML CTF assessment 30 November 2010 by Ernst & Young. Do you recall this document?
not specifically. It's 11 years ago.
And you don't recall Ernst & Young even being retained to provide such specific external assessments in relation to AML CTF?
I don't recall this specific document because it's dated 11 years ago. I suppose I have some knowledge that Ernst & Young was engaged, but it's a pretty dim memory.
Before 2017, do you remember how frequently specific external audits for AML CTF were conducted?
No.
If we go to CRW.702.002.2299, which is a legal risk and compliance board report for Burswood Limited for the period 1 August 2010 to 30 November 2010 at page 2304. Can you just enlarge that, please, so that Mr. Poynton can read it, and me too? The top. Report to the board that the following amendments are proposed to be made to the AML CTF program. Reducing external audits from every 5th year to every 2nd. Does that ring a bell with you now?
It does now.
Yeah. That prior to 2010, external audits were only taking place every 5 years. Do you recall
Yes.
that?
Yes.
Well, that wasn't nearly enough at the time, was it?
In 2010,
Yes.
again, what would cause one to think that it wasn't often enough if in fact there are, again, no red flags?
Because what's being assessed is the attempt to mitigate a risk of a criminal activity.
And indeed, for the next few years, there was no evidence of that. And indeed, it's only when you get to, say, 2018, that there's obviously a very large amount of concern about this, and the company responded to it.
Now, do you recall that the frequency of the performance of external audits for AML CTF were actually reduced to every 5 years after this?
I'm reminded of it here. I don't have a specific memory of it then.
One reason given is the extent of internal audit coverage. Do you see that?
Given the extent of internal audit coverage, AUSTRAC reviews...
Stay with the internal audit coverage
Let's-
for a moment. What did you know about that?
How do you mean?
What did you know about the extent of internal audit coverage as at 2010?
I have no specific knowledge of the extent of internal audit coverage.
Then it refers to AUSTRAC reviews. What did you know about the nature and content of AUSTRAC reviews as at 2010?
I can't recall. It's 11 years ago.
And it refers to recent positive outcomes of the Ernst & Young external review.
Correct.
What did you know about that?
Well, again, it's 11 years ago, but it's part of a picture that doesn't provide an independent director or a kind of non-management director of Burswood Limited, a wholly owned subsidiary, being presented with any cause for alarm.
So at CRW.702.001.0290, we have the minutes of the December board meeting at item 7. You're in attendance there, and the board endorses amendments to the AML CTF program. So it went from 2 yearly reviews to 5 yearly reviews.
Yes.
Well, that wasn't nearly enough, was it?
Well, I reject that again. One, this is 10 or 11 years ago. Two, the subsequent years would suggest that your premise is not sound. Subsequent to 2018, it clearly is identified that the company had issues. Now, again, we're sitting looking at what decisions this board was making at this time based on the information before it. And I don't agree that a 5-year review, based on all the other information, was a problem at that time. Subsequently, absolutely proved to be a problem.
But surely it would have occurred to you at the time that when you're dealing with a risk, such as criminal infiltration, money laundering taking place, that within a 5-year period, those who might wish to perpetrate such activities at Perth Casino might devise ways to get around Perth Casino systems.
Well, criminals have a predilection to get around all sorts of laws and issues. What I'm saying is this is not, in my recollection, the only place at which compliance around this legislation and requirements was occurring. There was, and still is, an audit committee at CRL. There's a risk committee at CRL, and I can't imagine, and I don't have the minutes for those meetings, those matters of those committees, that they were not discussing on a regular basis, certainly more frequently than every 5 years, compliance with the company's obligations under AML CTF.
Now, if we come back to page 0025, paragraph 100 of your witness statement, you describe over the course of your tenure as a director of Burswood and later Crown, observing an increasing risk for corporate Australia in respect of AML CTF. So over what period did that risk increase?
I believe, in my mind, I was referring to the period particularly around the accusations and subsequent convictions by the banks and I think Tabcorp of large-scale money laundering. And obviously this company is exposed to dealing in cash, as you said earlier at the outset, potential infiltration. So when we saw the actions against the banks, it increased my interest in and concern for compliance.
So when we look at the second sentence in paragraph 100, where it begins from around 2017, improving AML CTF compliance was a major focus for both the Burswood and Crown boards. You say you recognise it was vital for the business to do the two things you've specified in A and B. Is it your evidence that it became vital for Burswood Limited board to oversee that those two things were implemented, a regular assessment and update of AML controls and the allocation of sufficient resources?
My evidence suggests that it was both as a director of Burswood Limited at the time and then subsequently CRL, that this was an emerging and increasing area of concern. And so, yes, as a board member of Burswood Limited, this was, of interest and concern.
So it was a shared responsibility between the two boards?
A shared responsibility group-wide,
Well,
not just between two boards. But
you said it was a
group-wide.
major focus for both the Burswood and Crown boards, and
Yes.
I recognise that it was vital for the business to do these two things. See
So,
that? So
I'm
was
saying,
Sorry, you go.
I'm sorry, I'm saying it's a group-wide responsibility.
Well, What you've actually said in your evidence, it was a major focus for both the Burswood and Crown boards. You see that?
Yes. And clearly, from 2017 to the late 2018, I was not on the Crown board, but became aware from discussions that it was of concern to the Crown board. And then indeed, as I was moving into that position, there are numerous minutes of the Crown board meetings from which I took some comfort. In fact, I think it was the board meeting of May 2018 where there's an extensive reference to compliance with these laws and the concerns the company had about it. I was not yet on the board, but I was appointed but not actually, ratified. But that gave me great comfort that the company, before I even joined CRL, took this matter very seriously.
Now, just in terms of that then, was there any line of communication formally between the CRL board and the Burswood Limited board about respective responsibilities in relation to this area of focus?
The executive chairman of Crown CRL sat on the board of Burswood Limited, and there were discussions presumably on and offline about this matter. I don't recall specific discussions about them, but one can imagine that as a non-exec director of Burswood, having the chair of the company on that board and giving you either specific assurances or general assurances about these matters was of comfort.
Now, just coming back to paragraph B of 100, you say from around 2017, you recognised it was vital for the business to allocate sufficient resources to AML CTF to ensure that assessments and updates were properly executed. I'll just take you to a passage of your evidence before the Bergen inquiry. That's BGN.0002.001.3332 at page 3392.
Which particular section?
I'll just explain so that you've got the proper context before you answer the question. On this page, counsel assisting is referring to a report to the Board of Crown Resorts Limited at its September 2020 board meeting. And it's a report by the Crown Resorts CEO that's reporting back about the Bergen inquiry to the board. And at line 40, do you see there? Ms Sharp takes you to a pinpoint reference in this report. She says there's a heading, AML General Issues, and the second dot point is the AML team has been under-resourced and lacking in qualified AML executives.
Which number are we talking about?
Line 40?
30.
40.
All right.
Have you got it there? So she's taking you to a pinpoint reference in a report to the Board of CRL of September 2020.
Right.
And a dot point that says the AML team has been under-resourced and lacking in qualified AML executives. And she then asks you, is that an observation that you agree with? And you say, yes, it is. So do I understand your evidence to the Bergen inquiry correctly, that as at October 2020, you thought that the AML team in the Crown Group was under-resourced and lacking in qualified AML executives?
It was clear by that time that notwithstanding the numerous efforts of the company to address that, of which there are many, that it was a fair observation that they'd obviously not been able to do their job as well as they should have, and that was something the company then addressed as a matter of urgency. In fact, it was in the whole time, I think, from about 18 onwards, it was trying to scramble to catch up and appointing people like the head of financial crimes and people with the requisite amount of experience. And indeed, by this time, I think a lot of these things had been addressed. This is looking back.
Well, no, this is a report to the Board of CRL of September 2020.
The AML team has been under-resourced.
So no longer at that point?
Well, what I'm saying is it was part of a continuum that if you go again to the minutes of the meetings and and I have, there's a lot of discussion around ensuring that there's qualified people. There's clearly been accusations, probably in some cases justified, that there's not the right, outcomes. And so the company is on a journey, which is evidenced, to redress it.
Right, so between 2017 and 2020, when this became a focus for the Burswood Limited Board as well as CRL Board, and you were chairman from 2018 of the Burswood Limited.
No, I wasn't. I was chairman from 2020. I was chairman for 13 months through the entire period of COVID.
Right. Thank you. So on the Burswood Limited Board, between 2017 and 2020, what steps were taken to address this resourcing issue in relation to AML CTF by the Burswood Board?
I can't specifically recall what steps were taken, other than we were informed as to the steps that the CRL was taking. And indeed, as we got to the period, as I said, I referred to in mid-18, I was then accessing the meetings as an observer, seeing that there were substantial steps being made to catch up. It would appear in hindsight that the steps that were being taken back then were inadequate, but it wasn't as if there were no steps being taken. I took some comfort at that point, and this is after the period to which you refer, in 17, that the company was attempting to redress shortcomings.
Was it the case that the Burswood Limited Board did not take AML seriously until the Bergen inquiry exposed serious concerns about money laundering at Crown casinos?
No, not at all.
I'm going to change topics now and talk about junkets. At paragraph 72 of your witness statement, at page 19, 0019, through to paragraph 78, at page 0020, you give some evidence about the oversight of VIP international business and junkets prior to July 2019. Now, just so that I make sure I understand the effect of paragraphs 73 and 74 of your evidence,
Yes.
is it the case that the Board of Burswood Limited did not have any involvement or overseeing or implementing the strategy for attracting business to the Perth, junket business to the Perth casino?
Correct.
And is it the case that the Board of Burswood Limited did not have any involvement or in overseeing the conduct of junket operations at the Perth casino?
Correct.
You considered that the responsibility for oversight of marketing strategy for junket operations and conduct of junket operations at Perth casino was the oversight function was carried out at Crown Resorts Limited Board level. Is that right?
Yes, from the time of my engagement or involvement with Burswood Limited and subsequently, VIP has been a head office function, along with hotels and a number of other things.
Yet you knew that junket tours came to Perth casino, obviously.
I did, and as also evidenced in my statement, I think the maximum amount of profit ever contributed by junkets to Perth's profit was 3%.
And Burswood Limited Board considered such things as investment in jets and yachts to attract junket participants to and junket tours to Perth casino?
Indeed, without much success as it turned out.
But nevertheless involved to that extent, making decisions to attract junket tours to Perth casino.
Yes, my understanding from talking to people is that pretty much after the construction of the casinos in Singapore, it was very difficult to attract people to Perth.
You understood that junket tours increased the risk of money laundering through the Perth casino operations?
Generally, as I've said before.
And increased the risk of criminal infiltration of Perth casino's operations?
Yes, and it was a fundamental part of casino business in Australia, not just at Crown.
Would you agree that it was important for the Board of Burswood Limited to have oversight of the strategy for attracting junket business to Perth casino in order to properly address the risks that the junket business posed?
No, I saw that as a group or head office function, and therefore, again, the purview of the people on the board and the head of risk committees, etc.
would you agree it was important for the Board of Burswood Limited to have oversight of the conduct of junket operations at Perth Casino in order to properly assess the risk that those junket businesses pose to the Perth Casino operations?
No, because I was never given any cause for concern about the conduct of such junkets.
Would you agree with hindsight that junket tours to Perth Casino is something the Board of Burswood Limited and you as a director on the board should have taken a more direct interest in and responsibility for?
No, because there was no red flags raised and it was a very minor part of the business.
So if we go to paragraph 77 of your witness statement at page 0020, you refer again to, but in the context of junkets here, internal audit reports noted in the Burswood Limited board papers. Did you understand from the fact that you were being given these audit reports that the Burswood Limited board was being expected to have some level of monitoring or oversight of junket operations?
In the same context of the other matters to which were referred that related to oversight, yes.
Now, if we take the internal audit report that you refer to at 77A, CRW.702.001.2087. So this is a set of agenda papers for a Burswood Limited meeting of 8 August 2014. And if we go to page 2235, the reason I'm taking you to page 2235 is it's the front page of the document that you've pinpoint referenced in your witness statement. And it's described as a strategic internal audit plan for the financial years 2015 to 2017. Now, if we go over the page to section 1.1, I'll just blow that up so that Mr. Poynting can see it more easily. The purpose of this document is to set the focus and direction for the internal audit department for the 3-year period there specified between 2014 and 2017. And it goes on in the next paragraph. Do you see the objective of the department is to provide Crown Perth management and the board of directors with assurance and confidence over the effectiveness of internal systems and controls, etc. Did you understand that the board of directors there was a reference to the board of Burswood Limited?
Not necessarily, no, because Crown Perth is referred to, which in other places has in fact been referred to as Burswood Nominees Proprietary Limited, but I'm accepting that this was designed to, again, give the Burswood Limited board some assurance.
About the effectiveness of internal systems and controls.
Indeed.
Now, you therefore understood that the Burswood Limited board had some level of responsibility, oversight and monitoring of the effectiveness of the internal audit controls.
Correct.
Now, at page 2237, there's a reference to section 2, referring to risks and outlining the internal audit strategy to provide management and the board with assurance over these aspects of the risk. And section 2 then begins at page 2242. And the page you refer to is at 2249.
Where are we looking?
We're just waiting for page 2249 to come up, which is the one you've referenced in your witness statement. The ICB program is a reference to the junket tours program, isn't it?
VIP, yeah.
Yeah, but junkets is what we're talking about, isn't it?
Well, again, there's various terms, ICB, junket, premium, VIP.
It certainly includes junket business, doesn't it?
Yes.
Now, this is what you've referred to in your evidence as the audit plan. It says the effective and consistent operation of ICB programs is necessary for the company's reputation. Who do you understand to be the company being referred to there?
Well, I think the company in the broadest sense as a group, but also, you know, through the chain and as a citizen, a corporate citizen in Western Australia.
Well, Burswood Limited, does it include Burswood Limited?
All of the companies. So from CRL through to nominees and management.
So would you accept that this box that you've referred to here, or this row in your evidence, particularly in the second column, gives no detail to the board about the nature of the audit that is to be undertaken in relation to ICB business?
I would say that the very fact that there's a strategic audit plan that refers to the ICB programs and what needs to happen is evidence that the company is taking this matter seriously.
You see in the first paragraph, second sentence, an audit is scheduled annually due to the high inherent fraud risk and high transaction values.
Yes.
What did you understand that to be a reference to?
Well, the matters you've referred to before, that indeed junkets and international players have the capacity to conduct themselves in ways that might be prejudicial to the company's interests.
Well, were you concerned that that might not be referring to money laundering risks or criminal infiltration risks?
I think I took it that it meant an overarching view of the ICB program as it related to all those matters.
In any event, you don't recall making any specific inquiry of management as to whether and how a risk of criminal infiltration or money laundering through junket tours was audited?
No, it's 7 years ago, and as I said, I think the chairman of the company was on the board, so I'm assuming that there was some discussion around this. I can't recall it, but certainly I was given no cause to be concerned that the matters purview of the internal audit were not going to be covered.
Clock, Commissioner.
All right, just before we rise, it is important to us that we complete Mr Poynton's evidence today. So perhaps council can have a chat among themselves as to the processes of further cross-examination, bearing in mind the practice direction and bearing in mind also that the commissioners may have some questions. And we'll resume at 2 p.m.